A very good morning and welcome to the third meeting of the Criminal Justice Committee in 2025. We have no apologies this morning. And our first main item of business today is an oral evidence taking session on an affirmative instrument, and that is the International Organisations Immunities and Privileges Scotland. We are joined by the Cabinet Secretary for Justice and Home Affairs, and I also welcome to the meeting Susan Black, Senior Policy Officer with Civil Law and Legal Systems Unit, and Emma Thompson, Solicitor at the Legal Directorate, both of the Scottish Government. So welcome to you all, and I refer members to paper 1. And I intend to allow up to 15 minutes for this evidence session. And can I start off by inviting the Cabinet Secretary to make some opening remarks on the SSI? Cabinet Secretary.
Thank you, Convener, and good morning. The draft International Organisations, Immunities and Privileges Scotland Amendment Order 2025 is an order in Council made by His Majesty under powers in the International Organisations Act 1968. The nature of the reserved devolved divide means that where privileges and immunities relate to devolved matters in Scotland, the function of advising His Majesty in relation to the order is devolved. As such, this order deals only with those matters which are within the legislative competence of the Scottish Parliament. The purpose of this order is primarily to ensure the relevant privileges and immunities are in place for two international organisations, the European Forest Institute and the Global Combat Air Programme International Government Organisation, otherwise known as GECO. Additionally, committee members may recall that we committed to correct the drafting error in the previous Immunities and Privileges Order, and this order fulfils that commitment. In order to assist committee, I will say a little bit more about the background to this order. The European Forest Institute, EFI, and the UK Government have signed a host country agreement to formally establish an EFI office in London and requires certain privileges and immunities in order to function and operate effectively. The EFI is an international organisation set up to conduct research and provide policy advice on forest-related issues. The Global Compact Air Programme, GCAP, is a multinational initiative led by the United Kingdom, Japan and Italy to jointly develop next-generation fighter aircraft by 2035. The GECO will function as the executive body of the GCAP with the legal capacity to place contracts with the industrial partners. Defence manufacturing in Scotland is fundamental to our national engineering and manufacturing sector, and the Global Compact Air Programme is an important opportunity for Scotland and something that will drive future investment. This order in Council forms part of the secondary legislation needed to establish the GECO. As is common with recent privileges and immunities orders, this order provides for exceptions to immunity in respect of road traffic offences and accidents. In summary, passing this order will correct a historic error and, importantly, ensure that we are able to meet our international obligations. As a good global citizen, it is the responsibility of the Scottish Government to bring the order to the Parliament for consideration, and I commend it to committee. Thank you, Convener.
Secretary. So can I ask any members if you have any questions at all? No? Okay, thank you. So our next item of business is to consider a motion to approve the affirmative SSI on which we've just taken oral evidence. So can I invite the Cabinet Secretary to move motion S6M number 15946 in her name and make any brief additional comments that she wishes to make?
Move, Convener. Nothing further to add.
Thank you very much. Do members have any final points that they'd like to raise? No? Okay, thank you. So can I invite the Cabinet Secretary to wind up and press or withdraw the motion?
Press, Convener.
Thank you very much. So the question is that motion S6M number 15946, that the Criminal Justice Committee recommends that the International Organisations Immunities and Privileges Scotland Amendment Order of 2025 be approved. Are we all agreed? Thank you very much. And are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? Okay, thank you very much, and that will be published shortly. Thank you very much. So our next item is to consider a negative instrument. That is the Sexual Offences Act of 2003, Prescribed Police Stations Scotland Amendment Number 2, Regulations of 2024, and that's SSI number 377 of 2024. So can I ask whether members wish to make any recommendations in relation to this negative instrument? Otherwise, are we content that this comes into force? Content? Thank you very much. Okay, thank you. So can I thank the Cabinet Secretary and her officials for joining us, and I'll suspend this meeting for a few minutes to allow a changeover of witnesses. Thank you very much. Thank you. Thank you, members. So our next item is to begin our Stage 1 scrutiny of the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill. So I'm pleased that we're joined this morning by Simon Brown, President of the Scottish Solicitors Bar Association, Mr Stuart Munro, Criminal Law Committee Convener at the Law Society of Scotland, and Mr Paul Smith, President of the Edinburgh Bar Association. So thank you for taking the time to attend today's meeting and for your submissions, which were very helpful for committee members. Can I bring in Ben McPherson?
Thank you, Convener. I just want to remind Parliament of my register of interests as being registered on the roll of Scottish Solicitors at the Law Society of Scotland. Thanks.
Okay, thank you for that. So I refer members to papers 3 and 4 and intend to allow around about 75 minutes for this session. So I'll start with my usual general opening question, and I'll maybe come to Stuart Munro first of all, and then I'll bring in Simon Brown and then Paul Smith. So Part 1 of the bill makes a number of changes in relation to procedures in criminal courts, and I think the committee found your submissions very helpful in understanding or getting a sense of the overall views that your respective organisations have on the proposals. So I wonder if I can maybe just briefly ask you to outline any provisions in Part 1 where you perhaps have issues or areas of concern. So I'll bring in Stuart Munro first of all.
Thank you very much and good morning, members. The area where members will see there appears to be disagreement between myself and my colleagues on the panel today is perhaps most obviously in terms of the single national custody court. And I think in reality there isn't that much of a difference when one boils down to the detail. We at the Society support the notion that there should be flexibility in the system. If an individual person is arrested at one end of the country, has warrants outstanding in various different courts, it makes abundant sense, practically, for that person to appear before a single court and for the system to permit that. We are also open to the idea of investigating the possibility of remote participation in the custody courts. We had examples of that during the pandemic, obviously in a situation where there really wasn't much alternative in certain locations. And the experience was mixed, to say the least. And the panel will be aware that Chair Principal Marcia Lewis prepared a review of the pilot that was in place in the centre of Scotland, in Tayside Central and Fife. And she found, in short, the process to be wanting. It didn't really save any time. If anything, it caused more time to be wasted. And I think her ultimate conclusion was this could conceivably work provided there was investment in the courts, investment in the police, investment in the legal profession as well. Now, there is at the moment a working group convened by Sheriff Principal Anwar that is looking at the development of a virtual custody process that would meet the concerns that were expressed at the time of these pilots in the pandemic. And that work is ongoing. And I think the Society's view is we are open to the notion that this could work. It is likely to involve quite a bit of work and investment. It must guarantee that accused persons have an open ability to communicate with lawyers and take legal advice during the process. And it must guarantee that there is effective participation by the accused person in the process. And there are other considerations as well, considerations that would affect those who are the victims of crime and who have an interest in criminal proceedings as they take place, and to what extent the public ought to be given access to this and how that might be managed and organised. But we are in principle open to that idea, and I think the views expressed by the SSBA and the EBA effectively highlight some of the concerns that have already been identified and that we share, and that would require to be worked through before that could actually be applied in a more wide-ranging way.
Yeah. Thank you very much. I'm very interested to hear about the working group. I don't think I was aware of that. So I'm sure members might have some questions about the work of the working group in due course. Thank you for that. So can I bring in Simon Brown?
Yes, morning, members. Again, I'd echo everything that Stuart said. I think there's little issue taken with the bulk of Part 1. They all seem to be sensible and reasonable proposals. And equally, in general terms, our National Custody Court has some merit, but there are significant practical difficulties. And I was part of, there was a pilot scheme in Kilmarnock Sheriff Court as well, which I was part of, which was, I have to say, a singular failure. Courts took 4 or 5 times as long, were regularly running till 8 o'clock in the evening, and the communication with clients was very poor. I think people have to realise that we can talk about systems and we can talk about times and targets, but to echo a phrase that's been used for other things, these are people we're dealing with, and not only are people, they are vulnerable people, they have drug and alcohol difficulties, they very often have mental health issues, and they're at a very stressful time. It's important that we can communicate with them properly. Eye contact is important, body language is important, empathy is important, and you can't do that over a video link. You have to meet these people. There's also a much more practical level. Again, to give my court as an example, in Kilmarnock Sheriff Court there are 3 interview rooms. In Kilmarnock Police Station there is 1 video conferencing suite. So you're cutting the capacity of the court by 2/3. It takes 3 times as long to get everything done. So you do need tremendous... It's a great system in theory. It will require millions of pounds spent on it to make it work properly. And without banging on a drum I've banged on before, there are areas in the legal system where millions of pounds would be better spent.
Okay, thank you. Paul Smith.
Yes, thank you. Good morning. The question asked was about areas of concern, and the main area of concern I have is the virtual custody proposal, largely for the reasons set out by Simon and Stuart. There's almost a principled objection and a practical objection. The principled objection is, as Simon laid out, it would limit contact with clients, particularly when this is your first point of contact, as I've set out in my written submissions. Now, there will be many clients who've been through the system many times before who can adequately dealt with by virtual custody. But it's for those clients that have not been through the system before, who don't know a solicitor, this is their first point of contact. It makes it much more difficult for the solicitor to form an impression and effectively a personal bond with the client. There's also the issue that if they're released from the police station, they may have no contact details for the solicitor. They may have incorrectly stated their contact details or not known them to the solicitor, so it will restrict communication with the client. So that's the principled objection. I think better use could be made of virtual facilities later on in the proceedings. At first eye, it's full committals, because those clients who are still in custody at that stage will generally have been through the system before and will not potentially be so vulnerable. The practical objection is, as Simon says, the amount of money that would be needed to make this work. In Edinburgh Sheriff Court, there are 6 interview cells, so 6 clients can be seen at any particular time while the court is running. The times that virtual custodies have been tried in Edinburgh, there has been 1 room in St Leonards that is used both for seeing clients and for putting the clients through court. So when a client's being put through court, nobody could be seen, and that would obviously significantly increase the time it would take custodies to be put through. Now, that could be addressed. Again, as I've said in my written submissions, I think there's been a major refit at St Leonards recently. It was closed for about 12 weeks just before Christmas, but I don't know if that includes facilities to put more virtual custodies through or not. So that's my main objection to Part 1 of the bill.
Okay, thank you. And I think that that practical kind of issue around timing and availability of solicitors and facilities was certainly highlighted, and I think both your submissions. I wonder if I can just ask one follow-up question. I'll come back to Stuart Munro. I was interested in your submission on page 7, just at the bottom. And I thought it was quite an interesting point that you made with regard, and I'll just read out a bit of what was said. We consider as essential that directions under section 303K of the Criminal Procedure Scotland Act of 1995, which indicates that the court must issue directions for appearing by electronic means. So we consider essential that those directions contain measures that ensure that witnesses are not susceptible to any undue influence, and the effective participation of the accused is guaranteed. For achieving this, an appropriate connection network and suitable devices are critical. I was just wondering if there was anything more you want to just add to that. It was just an interesting point to raise.
Any attempt to take justice out of a courtroom brings with it challenges. And we entirely support the idea of looking at these things and trying to find ways of doing the system better, as it were. But if, for instance, you have a trial and a witness is giving evidence remotely, and that does happen. It happens already, and it happens in the civil courts as well. One thing that has to be considered is where a witness is participating from. If that's a police officer, it might be a police office, and that's probably going to be fine. You would expect the police officer to be aware of the need to be giving evidence in a suitably private and appropriate location. If it's a member of the public, they may need some further guidance, and it might be that greater care has to be taken to make sure they're not being overheard, they're not being put under pressure, or anything of that nature. In terms of participation by the accused person, and I entirely support what Paul says about the idea of remote hearings being used later in the process, procedural hearings like intermediate diets, it seems remarkable in this day and age that we still require people to travel across towns to go for a hearing that might last 2 or 3 minutes, if little is likely to be achieved at that hearing. But if you have an issue whereby an accused person has to participate remotely, what are they connecting to the court on? What if they don't have access to a suitable tablet, iPad or computer to allow them to connect? Should this be done in the solicitor's office? What then does that mean for the solicitor in terms of resources, both in terms of physical space, having a room reserved, having a computer with appropriate internet access and all the rest of it? These are the kind of practical things that have to be thought through when this sort of policy is being embarked upon.
Thank you. Thank you for that. That's helpful. OK, I'll open up to members and I'll bring in Liam Kerr, followed by Rona Mackay.
Yeah, thank you, Convener, and good morning to the panel. I'll stick with this virtual attendance and I'll stick with Stuart Munro for my first question, just on that exact point. You've set out, Stuart, in your response to the convener there, that these are the things that need to be thought through when you're putting a policy. This isn't a policy, this is a bill. So, given the concerns that you've highlighted, what should this committee be looking at in terms of amendments to this particular area of this bill, Section 2, in order to address those concerns? Or is this something that needs to take place outside the legislative process?
I rather suspect it's a bit of both. If you bear with me a second, I'll just look at Section 2. My immediate impression, and it's maybe something I would come back on if that's okay, but my immediate impression is that this is more likely to be a practical issue rather than one for the legislation itself. The legislation provides for the court giving directions about an accused person participating remotely or a witness participating remotely. The court will ordinarily regulate its own procedure, and one would expect that the court would have in place appropriate practice statements that practitioners would require to follow. But the court has to know what the options are. And fundamentally, if the solution is going to be that an accused person will be beside his solicitor when they are participating at one of these hearings, and that might well be the practical way to do it. If you have an accused person remotely participating in an intermediate diet, it might make sense for them to do so from their lawyer's office. But that does create challenges for the lawyers who then have to support that. There's no provision in the legal aid system, as matters stand, for that sort of provision to be given. And that then requires, I think, the government to liaise with the Legal Aid Board to consider what measures could be put in place to facilitate this, rather than simply creating the power in the bill or in the Act, and then expecting the courts to apply that power only for things to run into the sand because these processes haven't been carefully thought through.
I'm very grateful. It's a very interesting point you raise, and I'll now throw that to Simon Brown on the same point. Given that the SSB, in your submission, Simon, the SSBA is supportive of virtual attendance, but says You generally favour in-person attendance at trials, which is the default position. Are your concerns the same as those articulated by the Law Society? And is your generally favouring it an observation, or is there something to amend?
No, there are a wide range of types of virtual appearance, and I think it's already been. I mean, things like first diets, intermediate diets. There are a number of procedural hearings. I see no reason why those couldn't be dealt with virtually, although there is a caveat in terms of solicitor numbers I'll come back to. But if there is to be a finding of guilt, or if there's to be a question over somebody's liberty, somebody getting bail or not, then my view would, in all those cases, the person should be present in court. It is, though, as Stuart said, I think the difficulties are practical difficulties. Getting access to speak to somebody in detail via a video link is difficult. There aren't the number of independent rooms in the police stations we've mentioned. Your time's limited, and in particular, what we found in the pilot scheme in Kilmarnock was, having had an initial meeting with the client, if an issue arose, if a bail address had to be checked or something like that, it was very difficult to get a second meeting, because obviously my colleagues are thereafter in the system with their time slots. In terms of the example given about, you know, a client giving evidence from the solicitor's office, that could work provided you've got the office space to do it. Some of us do, some of us don't. But it raises a difficulty in terms of numbers of solicitors. Now, the committee will be aware that's something I have banged on about on a number of occasions in the past. But the fact is, there are an ever-decreasing number of criminal solicitors in Scotland. To use my firm as an example, and it's quite common, I'm the only criminal solicitor in my firm. If I'm at court doing a trial, I can't be in my office doing an intermediate diet. If hearings are held in court, there's a flexibility in court. We can say, I'll deal with this one in court 1 at 10 o'clock, and then I can deal with that one in court 2 at 11 o'clock. The virtual system takes that flexibility out of the system. It seems an oxymoron. It seems to design to put in more flexibility, but in fact it doesn't.
I'm very grateful. You raised the point there about practising as a solicitor. Just since Ben McPherson raised it earlier, I remind the committee I am a practising solicitor, although I don't do criminal law and I haven't done for 20 years. Paul Smith, on sticking with this virtual attendance, you or the Edinburgh Bar Association, in their submission, don't support virtual attendance at the custody court,
yes,
specifically. And I think you set out earlier practical issues, the cost. I think you said it needs millions earlier on. But you've also highlighted concerns about the effective communication between the person held in custody and the defence lawyer. Could you elaborate on that for the committee? And again, are there specific amendments that this committee needs to consider to the legislation to address those concerns?
Well, I don't think it was me that said millions. I think somebody else maybe said that. I did indicate there was a resourcing indication, or sorry, resourcing implication. So generally at the moment, I would go down to the cells and see a client. I would tell them my name. There's no provision in Edinburgh for me to pass them a business card because all the cells are sealed up. I can't pass anything to anybody through the cells. I can't even pass them a pen to sign a form. When they appear in the dock, I can give them my business card. Now, I will have taken all of their details. Sometimes clients can tell me their mobile phone number, sometimes they can't. Sometimes they tell me it wrongly. Sometimes they can tell me their full postal address, sometimes they can't. But on any view, they have my details. It's very common at the moment, if a client is put through by the duty solicitor, if the same client then appears 3 or 4 days later with the breach of bail, the duty lawyer's changed and they can't remember the name of the lawyer that put them through the first time round a few days later. So there are issues with clients remembering anything a solicitor tells them when they're in a custody situation. All they want to know is if they're getting out or not. And if they're told they are getting out, they tend not to pay much attention to what you say after that. So what I'm concerned is if there's no ability for me to give the client my personal details because I can't give them a business card because they're in a police station, they will then leave the police station with no way of contacting me, and I may have limited way of contacting them unless they've accurately told me their details. So from that point of view, as the case progresses, by the time we get to the intermediate diet, they may not have given me the information I need to apply for legal aid. I may not have been able to discuss witness statements with them. They will have been told virtually at court the date that they have to attend back, but if they've not got my letter telling me the date, they might not remember it, and it causes problems later on down the line. So that's my concern about it. And if you've had clients that have been through the system before and are existing clients of the firm, that's not so much of a problem. The main issue is with the clients who haven't been through before or who don't know how the system works. Those are the ones that this would serve least well, and those are the ones that the system should serve better because they've not been through the custody system before. So that's my principal concern about how a virtual custody system would work. Later on down the line, intermediate diets, first full committals, I'm all for it. As I've said in my written submissions, we don't do that at Edinburgh at the moment because that was a decision that SCTS took, because they think more is achieved by having everybody in the same room. So they took a conscious decision to have first diets not done virtually because they want everybody together, because they think that helps business be managed and helps business be done. So I think that reflects perhaps on the point that Simon was making, is that if everybody's in the same room, there's more chance of some form of resolution happening. But if people are remote, then it's less likely. Picking up on the point you asked about trials and the practical objections of that, if a client is in my office to conduct the trial, I then need to be in my office with him to conduct the trial. So at the moment, I would be in court. If the client's in custody, I think that's fine. We can do that remotely if the client's in custody. But if the client's at liberty, they would have to be in my office on some sort of link that I set up, and I would have to be with them. So the whole trial would then have to become virtual, because when I'm questioning a witness, then that would have to be done virtually from me in my office. So again, that's perhaps more a practical objection. Going back to your original question, I'm not sure if anything could be amended into the bill to assist that. But that's the type of objection I would have. So when the client is in custody at a trial, I think the system could cope reasonably effectively at the moment just by the client being virtual. If the client's at liberty, I think that's more problematic.
Yes, I understand. Thank you. Stuart Munro.
Yes, thank you. If I can just come back on a couple of points that Paul made. One of the things that Paul said about his experience of dealing with clients in the cells, or clients who are represented by duty lawyers, illustrates neatly the practical considerations that need to be worked through before a system like this can work. The example that was given of the client who's represented by Paul but maybe doesn't get the business card, or represented by duty and has no idea who appeared for him, or what would happen if that client was not physically in the court building, how would they remember that Paul appeared? One solution would be that at a practical level, if somebody was participating remotely, that they would receive a document, a kind of pre-designed document before they are released from the police station with the relevant details on it. Here are your court dates, here's the lawyer who appeared for you, here's his mobile number, email address, etc. And if we did that, it would, to some extent, meet the concern that Paul had. That requires people to work together to come up with sensible solutions to try and overcome these difficulties. And that is something that hopefully will come from the working group that I mentioned earlier on with Chair Principal Anwar. But the other point, just to make in general terms, is the criminal courts work with an enormous amount of goodwill, particularly from defence lawyers. If you go to the custody court in Glasgow or Edinburgh on pretty much any day of the week, you will see lots of people running around. And as Simon says, if we had perfect communications, if we knew at 9 o'clock in the morning what charges an individual was going to be appearing on, what the Crown's attitude to bail was, what the possible options for resolution might be, it would be very easy to go and take proper instructions from a client early on and deal with the case effectively. But very often that's just not what happens. The complaint isn't served until 3 o'clock. The fiscal isn't available on the phone. You don't know what the bail position is until shortly before the appearance, or indeed, suddenly you're hit with a bit of information that you hadn't anticipated. And you do require to go back and take instructions. And the trouble, as Simon says, is that the virtual systems that we've had so far have tended to be pretty inflexible. You have an appointment to see your client before the court, trying to get another one thereafter is nigh on impossible. We have to try and find ways of addressing these problems. And going back to Mr Kerr's point, that isn't really something for the bill, but it's something that has to inform decisions that are made around the bill.
Out of interest, Stuart Munro, on whom does the onus lie to make those changes that you've just referred to? Who could change that system?
It requires everybody to work together. I mean, so in the example that I gave in terms of Paul's concern, that ultimately will be presumably somebody in the police office who will have to press a button to generate a bit of paper to give to the accused person. But they won't necessarily know Paul's details, so we have to find a way of ensuring that they've got those details. So there then has to be proper engagement between maybe the court and the police, or the Crown and the police, or the defence and the police. It requires joined up working, in effect.
I understand. Thank you.
Rona Mackay, then Sharon Dowie.
Thank you, Convener. Good morning, panel. You've very clearly outlined your concerns about virtual custody courts, and I understand them. I wanted to ask you if you thought there was scope for the use of them in particular cases. In other words, if each case was considered in its merit, and I'm thinking particularly on domestic abuse cases. I know that's very much favoured by third sector organisations, etc. Is that something that you think is it possible, even if a pilot could be run to see if that would work at all stages of a domestic abuse case?
I can say that the Sheriff Principal of Grampian Highlands and Islands, Sheriff Principal Pyle, is leading a working group looking at just that. And what is being envisaged is a start-to-finish trauma-informed virtual domestic court model. The idea being that there would be perhaps a couple of sheriffs who were particularly trained, based maybe in Aberdeen or in Inverness, and that any time there was an appearance from custody in a domestic charge, ultimately in that whole area, the whole of the north, it would go to that particular sheriff. They would try then to have hearings thereafter conducted remotely. There's a particular advantage to that. I stress there are still disadvantages and concerns that have to be overcome, but the advantage is geography. Because if you are on an island in Shetland, for instance, and your local court is Lerwick, and that's still an hour away from where you live, or perhaps longer, and that sheriff in that particular jurisdiction is dealing with every type of case and doesn't have that particular training and experience in domestic abuse cases, there could be an advantage in having a specialist sheriff elsewhere hearing the case. There can often be issues of geography in particularly rural areas that are overcome by that kind of model. Now, you still have the problem of how do you ensure effective participation? How do you ensure that a trial conducted remotely is fair, that all of the necessary checks and balances are in the system? I think our view is it's not impossible, but there are challenges and they have to be overcome. And the other sticking point, frankly, in relation to that, or one difficulty that has arisen in relation to that, is funding. Again, for the defence, there's money for the Crown to do this, there's money for the court service to do this, there is as yet no money for the defence to do this, and it requires a different way of working, it requires additional resource from the defence. So there are, in answer to the question, I'm sorry to be so long-winded, there are models whereby that can be done. It is being actively looked at the moment, and it is something that may yet come to pass.
Oh, that's really helpful, thank you. So in other words, if the current pilot is successful, there could be ways of overcoming the difficulties you described to roll it out to other areas.
Possibly, and that's the purpose of the pilot, to see how it works in practice and to try and identify, again, like the sorts of problems that Paul described, the things that people don't think about but maybe affect one particular part. And there are, this isn't just a defence lawyer complaint. I should make it clear there are issues for the Crown. How do we support this? How do we actually facilitate this? There are issues for victim support, for those who have an interest in respect of complainers and other people affected by domestic violence. How can they ensure that their clients are properly supported through this process? And everybody is trying to work together in a really positive way to try and come up with solutions.
Yeah, thank you. Simon, do you have any thoughts on it?
Again, I mean, I echo the point. There's obviously some sense in particular in vulnerable witnesses being helped to give their evidence, and if that results in them giving their evidence either by commission or remotely, then that's a good thing. It doesn't take away from the problems earlier on in the system about custody appearances, but there are practical difficulties. At the moment, if you have a vulnerable witness and they give, let's say they give evidence in commission, so their evidence is pre-recorded, there are solicitors in the room, there are clerks in the room when that evidence takes place. If they give their evidence via a remote link from another room within the court, there will be a bar officer in the room with them. If you're talking about a system where witnesses are giving evidence from their kitchen table, you don't know what's sitting on the kitchen table in front of them when they're giving their evidence. You don't know if there's a big handwritten sheet saying, make sure you say that he did this and make sure you say that he did that. There's a safeguard missing there. Again, you could overcome it, but it involves probably people having to go at the very least to a dedicated centre, whether that be a police station or a local court. And again, it needs investment, it needs money.
Sure. Thank you. Thank you, Convener.
Thank you. Sharon Dowie, then Pauline McNeill.
Thank you. Good morning. First question would be for Stuart Munro. I think so the Law Society mentions that it's essential that directions contain measures that ensure witnesses are not susceptible to any undue influence, and effective participation of the accused is guaranteed. And to ensure this, that appropriate connection network and suitable electronic devices are necessary. Could you give more detail about the Law Society's concerns about undue influence and effective participation if the virtual appearances are made permanent, and also about the concerns around the stability and reliability of the network connections and electronic devices?
Certainly. The first point, the one about witnesses and safeguards, it's really the point that Simon makes. It is perfectly possible for witnesses to give evidence remotely, and there's nothing necessarily wrong with them giving evidence from their kitchen table. The concern, as Simon says, is making sure that they are doing so in a way that properly reflects the importance of the proceedings, that is the court can be sure isn't being compromised in some way by somebody off camera pointing at them and telling them what to say, or by them having access to documents that they shouldn't have access to or wouldn't have access to if they were giving evidence in court. Now, it might be that in very many cases that can be dealt with by the simple expedient of the sheriff having a word with them and making it clear and satisfying him or herself that is the position. But that's an issue that has to be thought about and has to be at the forefront of everybody's mind. In terms of effective participation, this goes back to this basic principle that you see in the European Convention about any trial process. Any criminal process has to be fair, and that includes ensuring that an accused person is able to effectively participate. And the point is simply that where somebody isn't in the room with you, it can be harder to ensure that they are effectively participating. We're not saying that it's impossible, far from it. But we have to think about how that can be best achieved. Simple example. At the very beginning in Glasgow, at the beginning of the pandemic in Glasgow, there was a virtual custody model tried that involved a video conferencing system that was frankly hopeless, where the accused person was a small dot on a screen where you could rarely hear anything that they said, and it really was very much a kind of box-ticking exercise. They're on the screen, therefore they're here. And that's not the same thing as being able to effectively listen to what's going on, to be able to put your hand up if there's a problem, to be able to contribute information back to the lawyer. So we have to make sure that those things aren't just given lip service to, but they are properly reflected. And the final point about connections and so forth, again, this is just the reality of life. We've all been, I'm sure the three of us have all been in courts many, many times where you have a witness joining remotely and the quality of the connection is very poor. That used to happen all the time, even in live links, where you had a witness giving evidence from another room in the same building. And actually, the newer systems like WebEx tend to be much better. But if you're dealing with a witness who's maybe giving evidence from home and they have very poor quality broadband, what happens then if you can't see or hear them, or if the link keeps dropping? And that can then knock the whole thing out of sequence. So we have to think about ways of ensuring that these links are appropriate. Does that mean we have to test it beforehand? If so, who's going to do that? Who's going to pay for that, etc.? Or, to borrow Simon's approach, do we have a series of places where people can participate from? Local libraries, for instance. If you have a couple of dedicated rooms where they can go in and have a private communication, maybe that deals with your concerns about influence. Maybe it deals with your concerns about the connection. Again, these are all things that just have to be worked out.
Okay, thank you. A question now for Paul Smith. Again, on the initial attendances, virtual attendances in custody, do you believe that custody appearances should be an explicit exception in the bill to the court's discretion in virtual attendance? And if so, are there any other types of cases that should be an exception to virtual attendance?
Answering the last part first, no, I don't. I think intermediate diets, first diets, full committals, procedural hearings, I think those have been done virtually before and been done well virtually before. Whether certain exceptions should be made to the virtual custodies, I think it goes back to Guy's point about whether things can be pick and choose which cases are done. In principle, possibly, but the issue is that that decision is likely to be taken by the Procurator Fiscal who marks the papers. So the first point of contact in the custody system would be the Procurator Fiscal looking at the police report and deciding how to mark it. On one view, it would make sense for them to take a decision as to whether an accused person should be brought in or whether it could be done virtually. The difficulty with that is the Fiscal is unlikely to have any experience as a defence lawyer. The Fiscal is unlikely to have any knowledge directly of the client other than the information the police have given them. So they might not be in the best position to decide who should and should not be brought. When this was piloted a while ago at Edinburgh, I think during COVID, I think the default position was that everything would be done virtually unless the solicitor wanted the client brought in. But if the solicitor said at 2 o'clock, right, I want the client brought in, that would cause enormous practical difficulties with resources in getting the client there. So I think in principle some exceptions could be made. I don't know if that would be done by record or whether somebody's previously served a custodial sentence, because that would be a reasonable indication that they've been through the system a few times before. But I think that would have to be set out as to what could and should be done, because if it was left to Crown Office policy, it may be wanting in that situation, I think. Can I just pick up on something that you asked Stuart about the practical difficulties of a witness giving evidence remotely? There's an issue with witnesses getting access to their statements and how that's monitored if the witness is not physically in court. So the general default position at a trial, if everybody's physically there, is a witness is not allowed to be in court before they give evidence when any other witness gives evidence. The notion of that is they might be tempted to change their position to either fit in with or contradict what somebody else has said. So the best way to ensure a witness comes in and tells the truth is for them not to know what anybody else has said. But a witness is entitled to view their own statement before they give evidence. And there have been significant issues in the past, in Edinburgh recently within the past 12 months, of witnesses going together, to each being given an own copy of their own statement and sitting together and reading them together with the obvious opportunity that they will compare what each other have said because it wasn't supervised. Now, provisions have now been put in place to stop that. When a witness asks to see their own statement, they're put into a room, given their own statement and allowed to read it, and nobody else has access to that. But how do you monitor that if the witness is remotely? The Crown are piloting or going to pilot something called the Victims Gateway, I think it's called, or the Witnesses Gateway, where a witness can effectively log in, view their own statement, sign their own witness citation. So if that's all done remotely and the witness is never in court, there is a possibility for witnesses comparing what each other have said and thereby contaminating their evidence. So that's again a practical difficulty with witnesses being remote. If a witness is remote within the court and they're monitored by court officials or bar officers, that's less likely, but there is that danger if a witness is entirely remote, particularly when they have digital access to their own statement.
Okay, so custody appearances, do you think there is a case for them being virtual? Because I thought there was kind of concerns about. My concerns are primarily people that have not been through the system before or who are not familiar with the justice system. Right. So if you look at, again, the example of domestic cases, anybody can commit a domestic offence, but quite often domestic offenders are first offenders, there are no previous convictions. So although it would be tempting to say we can do domestic cases virtually, the issues that I've highlighted, certainly to do with custody appearances, the issues that I've highlighted are to the fore in respect of domestic cases. You might have somebody with no previous convictions who's not been through the system before. You might be putting them through its duty because they've never consulted a lawyer before because they're a first offender. There might be issues with their address because their only address is the family home that they won't be allowed to return to because of bail conditions. So domestic custody appearances can be reasonably complicated. Domestic trials, however, tend to be quite straightforward. Those are some of the more straightforward summary trials that you will do. So I think it might be focusing it or picking and choosing on the basis of the accused going through rather than the basis of what they're charged with would be, I would say, a better way of doing it.
Okay, right. Okay, thanks.
Thank you. I think, Ben McPherson, do you want to come in on with a supplementary or not quite yet?
I'll come in later with a specific point.
Thank you. So I'll bring in Pauline McNeill and then Ben McPherson.
Good morning. There's a few things I wonder if you could maybe help me with on understanding some of this. technical subsections in this, because I think there's a lot more to it than I first appreciated. I suppose the first question I have is that, am I right in saying that what we've been discussing here is the possibility of virtual attendance, where the default position is that you would be expected to attend, but it's allowing for virtual attendance? Is that right?
I think that's what the bill says, but certainly when pilot schemes of virtual custodies were tried in the past, the default was the appearance was virtually, and it was the exception to bring them to court. And I think that's something that should be switched around.
Aye. So you feel there's some refining needed then as to what the criteria would be for virtual attendance?
I think we've all made. I mean, I think we all have misgivings about a default position being a virtual custody appearance.
So, but there's a separate proposal for national jurisdiction, and my reading of it is that is a separate proposal. And it's one that gives me a wee bit cause for concern, because the way you've been answering these questions is as if it's assumed that because we would be, well, let's say the bill was passed and we had national jurisdiction for custody matters, that they would be, by dint of that, would be virtual. But that isn't the case in the bill. What the bill is doing is removing the geographical limitations. Is that right?
That's correct. I think in practical terms, to make a national custody court work, it would have to be on a virtual basis.
Yeah. But the bill doesn't say that. And I've been plowing through the explanatory notes. I'm more confused than ever. And I can't see where the bill sets out that the bill is treating it as if there are separate provisions. Which I wanted to ask you a bit more in detail about the national jurisdiction, but I'm right in saying that.
You know, I would agree with that.
There's
at the moment an All of Scotland Sheriff Principal practice note that allows, if somebody has jurisdiction, if somebody has warrants, say, for 3 cases, say Dumfries, Dundee and Aberdeen, previously they would appear in Dumfries, then they would appear in Dundee, then they would appear in Aberdeen, so they'd be in custody for 3 days while they did all those appearances. Sheriff Principal's practice note allows the first court they appear in to deal with all their cases.
Yeah.
And that, I think the bill is effectively trying to put that into the national jurisdiction for custody courts. The virtual appearances, I would agree with you, is separate.
Right, so far what I'm thinking is that there's good reason on both counts, both national jurisdiction, if it was qualified, and virtual attendances, if it was refined to reflect some of your concerns. Would that be fair?
Yes.
Yeah, because according to the explanatory note, it's the Lord Advocate will decide which sheriff. That is quite a big departure from the principles of jurisdiction that we currently operate, or is it not?
If it's competent to raise, it could be competent to raise a complaint in 2 jurisdictions at the moment.
Yeah.
So, for example, if I have a client in Edinburgh who sends messages to an ex-partner who's within the catchment area of Dundee Sheriff Court, the Lord Advocate or the Procurator Fiscal could raise proceedings at the moment either in Dundee or in Edinburgh as they choose. They would normally at the moment raise it where the victim makes the complaint.
Yeah.
So in that example, they would normally raise it in Dundee. So from that extent, the Crown have that choice at the moment, if there is a choice of jurisdiction.
That makes sense. But does this not further extend the Lord Advocate's discretion then to go beyond that?
Yes, I mean, the Lord Advocate could choose to raise proceedings anywhere, but it would tend, I think, my reading of it was, it would effectively be the first court they happen to appear in would deal with all the cases they have.
Again, is it fair to say that for this to work, the bill, well, to reflect maybe your issues here, the bill's quite clear to me that the Lord Advocate's got complete discretion to decide sheriffdom, and if it's passed, then these powers will be there.
Yes.
Practically, if it's a trial, if all of your witnesses live in Edinburgh, then you have a trial in Edinburgh. I mean, that'll be the practical way forward. That you'll have your trials where it's most convenient for the witnesses to get to court.
Except the law won't say that.
No.
Right. You might not be able to help me with this, but maybe at a further date. I'm reading through the explanatory notice in relation to subsection 5. So the Sheriff Court has heard the initial calling of the case with the continued jurisdiction over proceedings and the Sheriff Court can preside over by a sheriff of any sheriffdom. So sheriffs can also go into the sheriffdom. Subsection 6 confirms that a continued jurisdiction can continue until the conclusion of proceedings unless the proceedings come to an early end. So far I can see that there's some sense in that, so where there's a guilty plea and it's a simple matters, then it gives some flexibility. I'm unclear of what it means in relation to petition cases, because the way the explanatory notes are written, it might be to get to the end, but what it says, proceeding on indictment that follows from proceedings on petition are to be treated as the same proceedings, and subsection 7 means the court which began the dealings with a case of petition can continue dealing with it. So I'm not sure if that is different. In practice, it says in practice, because jurisdiction under subsection 5, once it has reached indictment, in practice, because the jurisdiction under subsection 5 ends with an accused being fully committed for trial, is likely only to be relevant only where an accused makes a, I think, guilty plea. Right, I don't know if you can help me with this, but what I'm concerned about, unless I've misunderstood it, is that we're trying to get some flexibility here by virtual attendance with rules, national jurisdiction for good common sense, but in petition cases, I don't know what that actually means, but
I think there's an issue with that as well. So if, say, an accused goes through Glasgow Sheriff Court for an Edinburgh case, just using that example, if he's remanded in custody and he's fully committed, those hearings would be in Glasgow. But once he's fully committed, the case would go back to Edinburgh.
yeah.
If a person at the first appearance on petition is released on bail, they're not fully committed.
Yeah.
So in that point of view, jurisdiction stays with the court of first appearance, stays in Glasgow. We then have a first diet in Glasgow. The accused pleads not guilty. At that point, the case must be transferred back to Edinburgh because he's pled not guilty.
Yeah.
But if he wants to plead, it can stay in Glasgow. So on a practical level, who do I sort out a plea with? Do I contact the Fiscal's office in Glasgow because they're the court of first appearance? Or do I contact the Fiscal's office in Edinburgh? I've identified this in my written submissions, but I don't understand that either, and I think that needs to be dealt with, because it could then be left to Crown Office policy. Now, the example that I've used of Glasgow and Edinburgh is not a big deal on that, but say somebody first appears in Lerwick, do I then have to go up to Lerwick for a first diet to transfer a case back down to Edinburgh? That would seem not to be compatible with the aims of the bill. So I think that does need to be addressed, and it doesn't particularly matter which, but I think at the moment, as you say, if somebody appears in a summary complaint, an example that I gave of an Edinburgh-Dundee case, if I plead them in Edinburgh on a Dundee warrant and it gets deferred for a background report, it must then go back to Dundee. The bill would allow the case to stay in Edinburgh, which I think is sensible. But on a point of view of petition cases, I think there needs to be greater clarity and, in fact, a decision as to, after the first appearance, a set rule as to where the case goes. Does it stay in the court of first appearance or does it go back to the court of origin? At the moment, it's very difficult to transfer a case between sheriffdoms. You can transfer it within the sheriffdom easily enough, but with transfer between sheriffdoms is very difficult. I think the effort here is to make it quite easier, but in my opinion, it's not very clear.
Yeah, that's what I thought. Would you therefore have concerns that, given I've now raised 3 areas where, you've raised several areas where it does need refining, and I've suggested that the Lord Advocate has got much greater discretion on international jurisdiction, and what you've described in relation to petition cases, it just sounds like the bill, the way it's written, wants to go beyond the common sense initial procedures to give the court system a bit more freedom to decide where substantial trials would take place, given where they started off. Does it not concern you that maybe what's behind some of this modernisation is a bit more than making things practical?
Yes, and I think it comes back to the point of resourcing that Simon's made. There are issues at the moment with cases being transferred within a sheriffdom. Now, I'm based in Edinburgh, so it doesn't really happen so much because most of the jury trials happen in Edinburgh. But you may have a situation where Simon has a case in Kilmarnock and it gets transferred to Hamilton or somewhere to start the next day, or a case in Perth being transferred to Dundee or Aberdeen because they're in the safe sheriffdom, and the solicitor's just expected to go to Aberdeen. This would allow that to be,
Yeah.
those problems to be amplified. If a case could start and the person happens to first appear in Aberdeen, then the jury trial could be there. And if the accused is based in Edinburgh or Glasgow, they may have a lawyer local to there, so that may create practical issues. So yes, I think that's a fair point, that it may create problems giving effectively a national jurisdiction. Because even if a person appears, say, in Kilmarnock Sheriff Court first time, the case could then be indicted to Hamilton or could be indicted to Dumfries or anywhere within that jurisdiction of the sheriffdom of first appearance.
Yeah, that's it. I mean, they always talk about unintended consequences. Could you have a situation whereby it's a Glasgow case and Crown Office look at it and go, well, if we're going to prosecute this sheriff and jury in Glasgow, then it's going to take us 11 months to get a trial date. But if we move it to Perth or Dundee, we can get one in 4 months, so we'll just do that. Doesn't matter for the convenience of the accused or the solicitor or the witnesses, we can get it dealt with more quickly. And there's the point, I think I made by submission, you have to be careful. There's a distinct difference between faster and cheaper and better.
So, just finally, based on what you've said, not to get into any more complexity here, would it make sense for the committee to separate out the issues in relation to virtual attendance with the issue around national jurisdiction? Because although you're marrying it up, saying, well, the only way a national jurisdiction could work, but given what you've said, it makes sense for the committee to scrutinise the full extent of the powers that are being asked for under the national jurisdiction provisions, and separately to look at the rules around virtual attendance. Would that be your view?
I think you can also, from what you've said, separate. I think we would all be in agreement that the first appearance from custody being in any sheriff court in Scotland is a good idea. The issues you've identified with what happens jurisdictionally afterwards would be separate, and I think those could be further scrutinised, because I think there are issues there.
Thank you very much.
Could I maybe make just one point on in relation to the issue of transferring trials? That obviously happens at the moment in the High Court, which has a national jurisdiction, and I think it's probably less common than it once was. But there's still an issue sometimes of a trial that maybe emanates from Glasgow, ends up being called in Aberdeen simply because of court availability. And that has huge implications, not just for the practitioners, but for the accused person who suddenly has to decamp and go to Aberdeen for a period of time, but also for witnesses. And I recall being at a roundtable discussion some time ago where somebody who worked for one of the victim services expressed the concern about that kind of case, where you have a transfer from one location to another, where the witness is supported in terms of going and giving evidence, but the complainer, say, wants to go and see a sentencing hearing at the end of it, and that is still taking place in a faraway jurisdiction, and there's no funding for them to be supported to get there to go and see the sentencing hearing. There's no support necessarily from victim support to go and see the sentencing hearing. And these, again, are sometimes the unforeseen consequences of these decisions that have to be thought through where possible.
Thank you.
Can I just come in on that and pick up on that, Stuart Monroe? I mean, earlier on in your responses to Pauline McNeill, I think, Simon Brown, you said that this is an issue about sort of faster, and I think you said more efficient justice. I may be paraphrasing, rather than the sort of quality. Is that so? Is it trying to kind of get throughput and sort of speedy or more efficient service? Is that really the main reason why you would find situations where cases are transferred? So, for example, in the example that you gave, Stuart, with the High Court,
it tends to be about simple accommodation availability. There's a gap in the schedule somewhere that needs to be filled, and it will be filled by something that is the highest priority elsewhere. As to what might underlie the intention here, obviously I'm not so sure. I mean, there are, with all these things, there are positives and negatives. We can well understand why there might be situations where it makes more sense for somebody to appear in one location as opposed to another. There might well be good reasons for a trial to take place in one town or city as opposed to another, maybe where an accused person or witnesses are all located, for instance. It may be that there are cases where the location doesn't matter very much. But we can't at the same time lose sight of the principles of local justice, why we have sheriff courts in the first place. The idea of local sheriffs being able to respond to local concerns, being able to maybe have some knowledge of people who are frequent attenders before the courts. There is a danger of losing that benefit in the rush to try and have a more efficient system.
Yeah, okay, thank you for that. Okay, I'll bring in Ben McPherson and Katie Clark.
Thanks, Convener. Just first of all, touching on your answers thus far, the general position that I'm taking from both today and the written evidence is that there isn't an opposition to the principle of moving to utilisation of digital technology when it's appropriate and the modernisation of the systems that you operate within every day. But there needs to be due consideration to the practicalities and the resourcing. I thought, Mr Brown, your point about there's a consideration around faster and cheaper versus better, effectively. To me, that always makes me think of what the estimation for timelines should be in any change and reform. And the commencement section 28, you'll note, states that some parts of the bill would come into effect on royal assent or the 1st of December this year, whichever is earlier. Whether it's in response verbally to me now or following up in writing to the committee, I think it would be helpful for us to understand what you think would be a fair and reasonable time frame if Parliament was to pass this bill and the government was to resource it appropriately. Because I think that is quite an ambitious timeline, is my first reaction. But I would be interested in your practical insights from you and your members being on the ground, so to speak.
If you're talking about practical things, then I think the most obvious one is the video conferencing suites that the prisoners will appear from. There need to be sufficient numbers of them. They obviously need to have a set of geographical locations. So I don't know how long it would take to put that in place, how much money it would cost, but that's your bottom line. There have to be the numbers of them. So you're talking about, to make a system work effectively, an absolute minimum has to be 2, because you have to have one where you can have a consultation with clients and one that's used for the court. But as I've already said, on a practical level, you're significantly cutting your capacity as compared to what you've got in the Sheriff Courts now. So that's your basic point. But you're then talking about investment in courts, so there's video conferencing facilities available in courts. At the minute in Kilmarnock there's one room, so again, you can use it for a virtual court or a consultation, but you can't do both. There's a question as an aside that's been touched on a couple of times. Everyone else, the courts, the police, the Procurator Fiscal Service, they will all have their hardware provided for them. We'll have to provide our own. That's a resourcing issue that I think will have to be discussed as well.
So it's both the suitability and establishment of appropriate suites, to use your word, either in defence firm offices or in a public sector setting, to use Mr Munro's example, local libraries. There needs to be a clear agreement and understanding, and then facilitation and resourcing of these facilities.
And you're talking about, you have to have places with secure internet connection. You have to have places that are secure, that people can go in and give their evidence and be free from interference. They have to be in convenient locations, and there has to be enough of them to make the system work, all of which, as I've said, is a significant investment.
Thank you.
I wonder if I could come back on that. I'd begin by saying the Law Society's position on this is that it wholly supports the use of digital technology in the criminal justice system, and there have been some huge and very, very welcome improvements brought about really because of the pandemic and the response to it. We can now email the court in a way that we generally couldn't before. Documents generally don't have to be lodged in paper form in the way that they always did. And now you see, if you go to the High Court of Justiciary, you will see trials being done almost exclusively electronically, in the sense of nobody having paper files with them and documents being shown on electronic systems. All of these things are really positive changes, and there are no doubt many more improvements that could be made to make the system work more efficiently. much more sharing of information, much better communication between the participants in the process. The idea of the rules being based on a more digital structure rather than still requiring traditional ways of approaching things. But there are all of the concerns that we've expressed, and that will require people to work together and try and find solutions. Now, there is an issue as to the chicken and the egg in terms of whether Parliament should facilitate certain changes now to allow those practices to be developed and piloted and then in due course implemented, or whether it's appropriate to try and figure out how these things are going to be done before Parliament facilitates them. I think I'd be inclined to take up your invitation, if I may, in terms of coming back to you about specific comments on commencement dates. But I would stress the point that whilst there are many measures in the bill that are potentially capable of delivering improvements to all users of the criminal justice system, they will require work. They will require commitment of all parties involved in the process, and they simply can't be rushed. We are perfectly happy to engage in any way with developing these processes, but it has to be done properly before these procedures are put in place, because, as was said earlier on, these are real cases involving real people, real accused, real witnesses, real complainers, and we owe it to them to do this properly.
Thank you. And just in that space of the general issues that we've been discussing, Part 1 of the bill, as you know, sets out 2 new provisions aimed at supporting digital innovation in the criminal justice system. The first of these concerns the use of digital productions in criminal proceedings. Is there anything further that you would like to say about these provisions? For example, are there any issues which need to be resolved to ensure processes work fairly and efficiently that you've not stated already?
I think there's a huge amount of wasted time in the process of criminal investigations in complying with outmoded analogue ways of dealing with documents. So, for example, if the police are doing a financial crime investigation and they secure a warrant to recover bank statements from a bank, officers have to go to the bank to physically collect the statements. That's absurd in this day and age. It didn't happen during the pandemic because of certain emergency provisions that then disappeared. Likewise, in a financial crime investigation, officers have to go around getting things called Schedule 8 certificates signed for absolutely everything. That's simple documents saying, I certify that this thing is the thing I said it was, or that this thing is a copy of a document that we hold. Again, in the modern day and age, absurd. We should be far slicker in the way that we approach this thing, and we shouldn't be wasting officers' time in that kind of process. By the same token, we have to keep our eyes open in terms of the potential for making assumptions that might turn out not to be true. And there's got to be recognition of the fact that in certain cases, you are going to have to go and get the original document. But I think our system as a whole could be much slicker than it currently is in terms of the processing of evidence in that way.
And just on that, the second area in Part 1 covered by the new provisions relates to the authentication of electronic documents. I presume you think these provisions are helpful, but are there any problems which maybe need to be resolved in the drafting?
I think they are helpful, and I don't have an issue with the drafting as such. I am mindful of one point, though, and that is that the English provisions on the presumptions that should be applied to material that comes from computer systems that we don't have in Scotland are under scrutiny by the Post Office Horizon IT inquiry, and it's likely that there will be comment made by the chair of the inquiry when he comes to report in the early part of this year. That's something that I think we just all need to keep an eye on. So the English provisions go a bit further than the Scottish provisions have ever done or do in this bill. But the potential implications of assuming the accuracy of computer output is something that I know is going to be the subject of comment.
Well, thanks for flagging that, particularly as we move into stages 2 and 3 of this bill. Yeah, sure, please come in. Yeah.
I agree with Stuart entirely about we're in a digital age, we should have digital productions. My one concern, which I've highlighted in my written submissions, was in clause 4, paragraph 4 of the bill, and this is to do with images of physical evidence. So what that says is that a photograph of a piece of evidence is as good as the original piece of evidence. So a photograph of evidence is evidence. And the example that's used in the explanatory notes is of a knife. So if somebody's charged with possession of a knife at the moment, you have to physically produce that knife into court. It needs to be retained and produced. This allows for the police, what would normally be the police, to take a photograph of the knife, and then that photograph becomes the evidence, so you don't need to produce the knife. This might lead to the original knife being lost or destroyed and not available for the defence to inspect. So that's my concern there, is that if the police know that a photograph is as good as the real thing, they'll take a photograph, dispose of the real thing, and then after that it's lost. Now, that's not to say the police are doing anything improper in respect of that, but that's my concern with that specific paragraph.
So in such a situation, you would, although a photo would be appropriate in the proceedings, but you would want the original to be available and kept until the conclusion of the trial.
Yes, because an accused might say, I want to have that DNA tested, I want to have that fingerprinted, I want to have that analysed on my own. Now, that's not going to happen in a lot of cases, but in the cases that it may happen, it's going to be important. So I would just be concerned that that may result in principal or examinable evidence being lost because a photograph is good enough.
Can I say that I entirely share Paul's concern about that, but that, I think, is more of a culture and practice thing rather than the provisions of the bill, because the bill makes it clear that the court can otherwise direct. And, you know, there are, as I say, bound to be instances where the individual entity, the thing that is a piece of evidence, does require to be seen. The kind of classic example of that might be the document where it's suggested that the document was forged, where it wasn't that particular individual's signature on the form and the photocopy just doesn't make it clear enough. There are bound to be cases where the provenance of the original thing is an issue, and everybody needs to know that there has to be a mechanism for challenging that.
We could consider, as this bill progresses, whether retention of the original thing, to use your phrase,
yes,
is a requirement until the conclusion of the trial process, and perhaps indeed for some time thereafter in case of appeal and these sort of things. One more question?
One more, very quickly.
So just moving slightly off that topic, but the bill does not seek to make permanent the current temporary provisions extending some time limits in solemn cases. Do you have any views on whether the system is on track to cope with pre-COVID time limits by November this year, when the temporary provisions are due to expire? I know colleagues across the table have raised this issue in the chamber. Do you want to say that again, Mr. Brown?
Categorically not. The time limits are extended on a daily basis. They're nowhere near pre-pandemic time limits. Time bars are extended in just about every single solemn case that I deal with. No chance.
Can I qualify that? I mean, there's essentially two time limits in the legislation. Okay. One relates to the time that the Crown have to bring a case to court, the service of an indictment, and the other relates to the commencement of a trial. So the bringing the case to court is in the hands of the Crown, the commencement of the trial is in the hands of the court. I agree with Simon entirely in terms of the second one, that once a case is in court, once a case has been has been indicted and an accused person has appeared in court and a trial has to be fixed, it is never the case. It's not that sometimes the time limit is breached, it's just never the case that the trial time limit is complied with, and the courts routinely and as a matter of course extend those trial time limits all the time. And that is a matter of concern, because we've gone from a point where those time limits were often breached to one where they just are always breached, and that nullifies the purpose of having them, arguably. And it's very difficult to see the courts being on track to get to the point where we are going to have trials within those time limits, the 12-month time limit in a bail case. In terms of the other time limit, though, the time limit for the Crown to bring a case to court by service of an indictment, it's harder to see why there is any continuing justification for that. The courts can't accommodate trials because of the backlog. the Crown doesn't have the same justification. You know, we're long past the pandemic. A case that is reported to the Crown today should be capable of being investigated and turned around within the time limits that were applicable pre-pandemic. So I think, in answer to your question, I don't think, or I would be interested to hear the Crown's justification for the first of the time limits being kept at this extended level. It's more difficult to see us getting back to a point where the second of the time limits, the trial one, is actually complied with in the majority of cases, although that absolutely should be the intention. It's a scandal, frankly, that you have people being held in custody for years on the basis of unproven allegations. The remand is a fact of life and it is unavoidable in certain cases, but we have a duty to try and keep periods of remand to a minimum, and we shouldn't be in the situation that we're in at the moment.
Thank you.
Thank you. Katie Clark.
Thank you. And the evidence that you've just given on time limits is highly concerning. And if you wish to provide more information to the committee, I think that would be something we'd very much appreciate. And as you say, it would be interesting to also get the Crown's perspective on these issues. In terms of the bill that we have before us today, and in terms of national jurisdiction, you've given evidence very clearly that you can see many scenarios where this may be helpful and appropriate, but you've also expressed quite considerable concern. In terms of the concerns that you're raising, and given that it will be a range of different types of cases where this provision would apply, it would be in Solomon summary cases, it would be in cases at very different stages, perhaps cases where there has already been a very lengthy trial, someone's appearing from custody, where a particular sheriff or judge has got a great deal of knowledge of a case or an accused. Do you think there could be more detail on the face of the bill in terms of the kind of criteria that would need to be used in relation to national jurisdiction, or do you think there is a requirement for more detail, for example, in a practice note or in rules of court? Is that something that you've given any consideration to, or you could assist the committee with? So if we agree, if you like, to the principle, do you think there maybe needs to be more fleshed out in terms of criteria and safeguards and protections? Simon.
There would be difficulties in if you try to do it in the bill would require to be far too detailed and would inevitably lead to there would be a loophole. There would be some. It would happen, but the converse of that is yes, there would have to be practice notes on a quite detailed level about what was done, and those would have to involve quite a bit of input from all the relevant parties. I mean, I think it's to use Stuart's very good example of giving a contact sheet to an accused. That involves the police giving it to him, it involves SCTS getting all the appropriate information, and it involves the solicitor providing the information, up-to-date contact details. So you've got 3 different agencies there that have to coordinate. So there will have to be a practice note, undoubtedly, because as we've already, there's a large number of issues that are going to arise.
I'd agree with that entirely. I think it's a difficult thing to provide for in legislation, but we would all benefit from having a clearer idea of the circumstances in which this would be applied and how courts are meant to then respond to it.
No, I would agree. I would agree entirely.
Thank you. And Convener, if I could ask a question on stage 2 of the bill, and as you know, part 2 of the bill, which sets out a framework for a system of domestic homicide and suicide reviews. Is that something that you've looked at? Have you looked at the provisions in relation to those aspects in the bill, and is it an area that you've got any views that you'd be able to share with the committee?
I always take the view I'm here to give an input on practical things in the running of the day-to-day court, so I don't have a particular...
No.
Again, I've looked at them, but I didn't think it was anything I could helpfully assist the committee with. It seems to be fairly straightforward what the objectives are, and I don't think anybody can disagree with those objectives, so there weren't any practical things that I felt the need to raise with the committee at this stage.
Okay. Likewise, I think the Society entirely supports the principle and the manner in which the process has been set out. There have been cases, there are sadly all too often cases, where people feel, families feel, or individuals feel that matters have not been properly looked at or investigated by the police, or dots have not been joined properly by the authorities when dealing with cases, and any effort that can be made to try and address those concerns is to be welcomed.
Thank you.
I think Pauline McNeill, you want to come in with a brief supplementary, and then I'll bring in Fulton McGregor.
Yeah, thank you. I just wanted to come back on the answer you gave to Katie Clark on the practice note. So it does relate a bit to time limits in solemn cases. As you know, when we revised the time limits in law, remind me what year that would have been, but it would have been 2004, 2005, something like that. And we changed the test to make it on cause shown. In good faith, the Parliament and legislators thought there wouldn't be much change, but there was significant change, you would agree. So in that context, the national jurisdiction question in the bill, so the provisions in the bill, is it not fair to say that if we dealt with these concerns by only a practice note, same thing's going to happen as happened in 2004? Is it in good faith? So if we don't put something on the face of the bill that provides some framework for what the limitations would be, but a practice note could just be completely ignored?
Well,
or not?
I suppose yes, in theory, a practice note can be ignored if justification can be found for ignoring it. I mean, I suppose that depends on the wording of the legislation. I don't think, to use the example of time limits, I don't think when time limits were changed, anyone envisaged the stage that we would get to just now. But there are a huge number of factors that have led to that. You know, physical accommodation, lack of number of advocates, lack of number of defence solicitors, and an increase in historical offences. So, but I suppose,
is there a middle ground? Is there something else rather than a practice note?
The middle ground might be for it to be in the Act of a Journal, so the secondary legislation that's made under the criminal procedure legislation, which is a place that the courts and practitioners refer to all the time to see how certain things should be dealt with. So that might be an answer. Specifying the considerations, the criteria that might ordinarily be thought to justify treating something as a national case.
Thank you. Thank you very much.
Okay, thank you. We're just coming up to time, but I know there are one or two more questions that members want to ask. So if our panel are prepared and able to bear with us, we'll run for maybe an extra 10 minutes or so. So on that, I'll bring in Fulton McGregor.
Thanks, Convener. Good morning to the panel. Apologies, I missed the first part of the meeting. I was actually at the Petitions Committee. It's a petition that I've had a long-running interest in. But the reason why I mention that is I run the risks now of the question I'm going to ask. You may have already answered it or have touched on it, and if that's the case, please just tell me. So it's going back to the provisions that are temporary, that are looking to be made permanent. And the third of those relates to higher fiscal fines with a maximum of 500 rather than the pre-COVID 300 maximum. So in principle, can I ask, do you see the offering of fiscal fines as an appropriate option? And if so, in what types of cases should they be used? And do you feel there are types of cases where they should not be used at all? Quite happy with whoever wants to come in. Simon?
I think on a practical level, something that's been picked up in the press, you see, for example, the effective decriminalisation of shoplifting. Shoplifting becomes an offence which is viewed as a low-level crime. It's dealt with by fiscal fines. Those fiscal fines are not paid because these are, in many cases, drug addicts who don't have the funds to pay it, and they simply just continue to shoplift and continue to get fiscal fines, which rack up to an extent that you then come into a court hearing 6-7 months down the line with complaints with 20 charges on them. So you have to be careful with that. I mean, the obvious answer is yes, they are appropriate for low-level offences, but who decides what's a low-level offence?
Yeah, and I suppose just following on from that then, because my follow-up question actually probably goes where you were going there. Have you seen any examples of you know, the fines up to £500 being used inappropriately? Is that something you've came across in your practice? If you can comment on that, you know, is there...
I can comment in general terms because it happened to me just last week where somebody appeared in court charged with an assault, and on looking at the previous convictions, they had 4 fiscal fines in the last 12 months for assault. And you would think that somebody should have been looking at that and thinking, well, there's clearly an issue here. This person should perhaps be looked at a bit more closely. So you run a danger if you have a criteria of, I'm speaking a shoplifting less than £50 or an assault where there was no injury. Yeah, that's automatically a fiscal fine. You have to be careful about making generalisations that all of these cases will result in a fiscal fine, because you might miss patterns there.
Okay, thanks, that's helpful. Stuart, Paul, anything to add?
I think the issue might be how the Crown interpret this and how the Crown use this to influence their decision as to whether to issue a fiscal fine. If they look at a case and think, if I bring this case to court, they're not going to get a fine of more than £500, so I might as well issue it with a fiscal fine. If that's their logic, then what Simon said happens is going to continue to happen if you look at cases individually. So I think it's maybe better for the Crown to answer that question on the basis of how is this going to affect whether and how they issue fiscal fines in the first place. We tend not to see fiscal fines unless they appear on somebody's record after they've appeared in court. Because if the client decides they're going to pay it or ignores it, that's not something that we deal with directly. It would only come up, as Simon says, if we see on somebody's record they've been issued with a number of fiscal fines.
A couple of issues with it. I mean, I'm sure most people would support the idea of not criminalising people unnecessarily if there is a way of dealing with a case that doesn't require the engagement of the criminal justice system and that isn't going to cause any problems, then that can be a good thing and consistent with policy. Flip side is that it's not just about what the penalty is going to be. You know, and Paul's entirely right. I suspect that is part of the consideration. This charge isn't probably going to result in anything more than a fine of £500, so let's give a fiscal fine. Problem with that is, A, it fails to, or it might be seen by the complainer or by the public at large as failing to take things seriously. If you're Tesco in Sauchiehall Street and fed up with the number of shopliftings that are taking place and saying that every single time somebody's arrested they get a fiscal's fine and it doesn't make any difference to the practical experience, they may not be happy. If you're a concerned resident about antisocial behaviour by young people, you know, whether it's vandalism or threatening behaviour or things of that nature, and they contact the police because they really need help, and all that ultimately happens is the offender gets a fiscal's fine and it just keeps happening, then again you might feel that the criminal justice system isn't supporting you. And if you're an accused person who faces an allegation that you think is untrue, but you've had a fiscal's fine and the easier thing to do is just to fill in the form and pay the money, then again that's not very satisfactory. So it's a measure that has a place. There is a danger in its overuse. How you police that overuse is another matter altogether.
Just to come back on that last point, because I did an example of that last week, there's also a danger because this is members of the public who don't have the necessary legal expertise. Somebody came in to see me with a road traffic fix penalty, and their first line was, I'm happy with the fine and I've paid that, but I don't accept the points. And I had to explain to them, well, you've paid the fine, you've accepted the fixed penalty, that's it, done. And they didn't realise that. So that's a danger as well with fixed penalties, that people don't perhaps know what they're accepting or not accepting.
So, just come right out and ask it, should this, in your view, should this current temporary measure be made permanent?
I personally think the increase isn't a problem because it reflects inflation over the course of the last number of years. There is a wider issue about, I suppose ultimately a much wider issue about how do we expect the criminal justice system to work? Because Parliament can pass laws and criminalise behaviours. If the police don't investigate, or if the Crown doesn't then prosecute, then what impact is actually the legislation having? And there is a question, I think, that would be usefully considered, maybe by this committee, maybe by Parliament more generally, as to when conduct is criminalised, what do we expect to see happen with it? What types of conduct do we think justify a fiscal fine as opposed to a prosecution? What situations would we expect there to be a prosecution, such as in the case of Simon's client with his 4 previous fiscal fines? I'm not sure anybody really knows the answer to that.
Okay, thanks, that's interesting. Thanks. Kavira.
Very brief supplementary from Sharon Dowie, very brief, and then I'll bring in Liam Kerr for a final question.
Thank you. So, very, very quick question then to Simon Brown. You'd mentioned earlier on about a pilot in Kilmarnock. I think you described it as a singular failure communication with pilot clients, was poor, and court's been on to 8 p.m. I was just wondering, have all the learnings from that pilot been put into the bill? And also, I don't know if there's a copy of a report on the findings from the pilot that could be made available to the committee.
There should be one. It was finished off by Sheriff Principal Anwar, who's now doing the wider virtual one. I think it was practical failings rather than procedural ones, and I think the main one was the lack of capacity that I've touched on already. There being the one room in the police station, that was what slowed things down. There's also a bigger. I mean, everyone talks about how this will work, and you say, papers will be available. And as I said, we're coming into what's called summary case management, where there's even more onus on the Crown to provide even more disclosure at an early stage. There were 11 custodies in the custody court in Kilmarnock on Monday. The custody court starts at 12 o'clock. At 12 o'clock, there was one set of papers available. And I don't see how that's going to change just because you make them virtual and not in person.
Okay, thank you.
Thank you. And Liam Kerr.
Thank you, Convener Simon Brown. I just want to take you right back to something you said earlier on, just to make sure we air this. You talked earlier about the need for legal aid provision for solicitors when they're dealing with virtual attendance. We already know that in a context where there's a significant decline in such solicitors, legal aid, many will feel, is less than ideal already. Can you help this committee understand what legal aid is currently available, if at all, for virtual attendance, and what are the issues around legal aid generally?
Well, the issue, legal aid for a virtual attendance would be the same as for an in-person attendance. So there are two different types of legal aid. You can have what's commonly summarised as ABOR, which is advice by way of representation, which is for a plea of guilty or a continuation without plea, or if you plead not guilty, you can apply for legal aid. There's already an issue there because there's different financial tests for the two, and it's easier to get legal aid than it is to get ABOR, which has in the past tended towards, in borderline cases, a preference for pleading not guilty rather than guilty. That was something that was addressed in the case management programme, but needs further work. But the bigger issue is not so much the types of legal aid that are available, but the levels of legal aid and the impact that they've had on the profession. You're now at less than 450 criminal solicitors doing work on a regular basis in the whole of Scotland, and of that 450, about 150 doing roughly 50% of the work. We can't attract new solicitors into this branch of the profession. The wages available in commercial work are quite often twice what can be paid in criminal work, and more are leaving the profession every week. These schemes that you're talking about involve investment in fiscals and bringing more fiscals. Those fiscals inevitably come from the private sector and take more away. Without significant investment, you're not going to have the numbers of criminal solicitors to deal with the cases. And the example I gave earlier on of, I'm the only solicitor in my firm. If I'm at court doing a trial, I can't be in my office doing a virtual custody. If we were properly resourced and I could bring in another solicitor, then that might work more smooth.
Very grateful, thank you.
Thank you. Okay, that's us just a little bit over time, but I think it's been a very, very helpful session. So can I thank everyone for joining us today? That's been most appreciated, and we'll have a short suspension to allow a changeover of witnesses. Thank you. Thank you. Okay, thank you very much indeed. So we're now joined this morning by our second panel. So welcome to Kate Wallace, Chief Executive Officer at Victim Sport Scotland, and Adam Statura, Associate Director of Policy Communications and External Affairs at Age Scotland. So welcome to you both, and thank you for your submissions which were circulated ahead of today's meeting. So I intend to allow around about 60 minutes or so for this session, and as always I'm going to open up with a general question with regard to the provisions in parts 1 and part 2. Now, I appreciate that you probably, each of you probably has a stronger interest in different parts of the bill. In Kate's part, you're interested in part 2, and Adam probably more interested in part 1. So what I'd like to just really ask is, the committee certainly has a kind of overall sense of your views on the provisions in the bill, but I'd specifically like to ask about any areas of concern that you have on the bill. So I'll maybe bring in Adam first of all, and then I'll bring in Kate, and obviously you can refer to whichever part of the bill you're interested in. Adam.
Thank you very much, Convener. As you said, I think our take from Age Scotland is part 1. I don't think we've got anything to add in value for part 2 with our expertise or insight, and I'm sure Victim Sport Scotland will have a lot more there. Obviously, you said that there's a lot for us to talk about in elements of part 1, but broadly speaking, the provisions in it feel like they could do a good job. That's kind of the start position, but you're asking the question around where the concerns are, and actually it's not so much a concern around what will happen on the face of the bill or be required, is like where there might be some kind of mission creep in terms of access to criminal justice services. If there is a considerable digital transformation in the service, which actually behind the scenes is got to be welcome, and it's something I'm sure that all public services really need to do and probably need to evolve with a digital transformation, is ensuring that older people in this circumstance for us, when they're interacting with the services, that it doesn't become the situation that they can only or primarily access it through a digital kind of front door, as we're seeing in some other places, such as with the NHS, although there might be provisions there. So it's not so much what happen with this right now, but down the line, more and more people, of course, will be digitally native and comfortable, but will the service itself feel that in terms of speeding up the next phase of it, not just our own administration, but indeed how we get information in, how we interact with witnesses or the accused, that it is primarily digitally, and the options for in-person, face-to-face, translated services, everything else that you'd require is really, really hard to access. So I think it's definitely, to summarise that, it's what happens next. But there's a lot in this which you can see how you'd make the system more effective, faster, more sort of understandable for the public, and that'll definitely where our contribution today and of the paper is focused.
Thanks very much. And just by way of a follow-up, in your submission, there's some helpful information with regard to the extent to which some older people are still excluded, if you like, from the digital space, and that was very helpful to set that scene. I suppose I was interested in, in that regard, the experience of the pandemic, and if you've got any sort of comments on the impact of the pandemic on older people, and whether or not there was perhaps a kind of positive outcome insofar as it maybe brought older people into the digital space where they might not have been. So I'm just interested in whether we saw a little bit of that shift happening.
Without doubt. I mean, I think before the pandemic, if I'd been sitting giving evidence at a variety of committees since Parliament, I'd have been talking about the 500,000 pension age people in Scotland who didn't use internet. Now we're at 500,000 over 50s. So there has been a change in terms of, there's still 500,000 people older, but there's definitely been a change of those who are digitally connected. The caveat here, though, from a lot of research fairly recently is about just because, and I think this is really a question for parliamentarians, on this and thinking about how digital access is. Just because you're online doesn't mean you're very good at using it. And about just over a third of older people who are online are really not good at using the internet, are quite frankly unsafe doing so by lots of the tests that Lloyds and others have with regard to their digital inclusion work, and tests like, actually, can you change your password? Can you open a browser? Do you know where to access, save a file? Can you know all these things you might take for granted if you're doing it on a routine basis? Tell a different story by the quick figure of, do you have access to the internet compared to how you can navigate and use it? So I think this there's a wide variety of expertise. And the last point on this, I think we've got to always remember, is there will be a generational shift. More people, of course, will be using the internet, using digital devices, but those who are primarily not won't change for lots of reasons. Those who are on low income or living in poverty are further behind in terms of their inclusion through digital experiences. Those who have disabilities or disabled, equally so. And as we're going to see in the future, a growth of people in low income and financial insecurity in later life, and indeed we're going to have a rising older population, the fastest in the UK in terms of increasing population. More people will have disabilities and be disabled. So just because there is a generational shift doesn't necessarily mean the numbers of people will change vastly, but there'll be critically people who really need access to types of support who are digitally excluded. So just there's my caveats on all those points for a little bit extra information.
Yeah, thanks for that. I mean, that was very clearly set out. OK, I'll bring in Kate Wallace. And just a reminder, my original question was just about issues and areas of concern that you might have on the bill.
Thanks, Convener. Yeah, I mean, we welcome the bill and the aims and intentions of Part 1. We particularly welcome the establishment of a statutory review function for murders and suicides in the context of domestic abuse that's been set up in Part 2. In terms of your specific questions around concerns, there's a couple we would want to pick up in Part 1 around Sections 2 and Sections 7 that we can potentially get to. Part 1, sorry, and then in Part 2, there's just a couple of points of clarification that we would want to make around the membership of the committee, in particular, and around publication of reports and involvement of families within the process. But we can probably pick that up.
OK. Right, OK. On that, then, I'll just bring in members, and I'll come to Liam Kerr first.
Thank you, and good morning, panel. I'll go to Kate Wallace first of all, please. You mentioned Section 2 and 7 there. You didn't mention Section 6 about the fiscal fines. Section 6 is effectively making this temporary COVID measure on fiscal fines to the maximum level to 500 permanent. In your submission, Kate Wallace, Victim Support Scotland has supported that, but you may have heard Simon Brown in the earlier panel saying that it could be an effective decriminalisation of shoplifting with fiscal fines. And Stuart Munro went on that a fiscal fine could lead to a suggestion that an offence is not taken seriously by victims and in general. So what is your view on both the principle of a fiscal fine, but also do you have any concerns about permanently raising the limit to £500?
So our main point, I suppose, about fiscal fines is about communication with victims about that as being the outcome and being clear with victims that that's what's happened. We haven't asked victims around, and it's not an issue that's cropped up really particularly for us, unprompted from victims. We don't have a view that's based on a view from victims for fiscal fines on that. I did hear some of the evidence in the previous session, so it is something that we'll take away and speak to victims about specifically.
I'm grateful. Just on that, because you're right, in your submission you do talk about, you seek assurance that communication for victims whose cases are settled with a fiscal fine will be a priority. Can you help the committee understand what's the current situation, what happens at the moment, and what is it that you want to see change?
That's something that I think we should do some more work on to bring back to the committee and dig into that in a bit more detail. It's not something that we've looked at hugely, as I say, because it's not come up
from victims to us, particularly. So I think we'd be best placed to go and gather some more information about that to be able to answer your question properly.
I'd be grateful if you would, because you've said in your submission you seek assurance, and it will help the committee to understand exactly what you mean by that. Convener.
I wonder if I can just come in, sticking with part one, and I'll come back to Kate Wallace. I was interested in your submission with regard to your comments on digital productions and the sub-proposals around that. And I was interested in the comments that you highlighted, quite rightly, with regard to, I suppose, the issues that victims of sexual crime potentially might have to face with regard to personal effects, clothing, that type of thing, being taken possession of for forensic examination and productions. So I'd be interested in just hearing a bit more about why you think that particular provision is a positive step forward, if you like, in that regard, with particular reference to sexual offences.
So you're talking about digital evidence sharing capability, and I mean, I think the feedback that we have had from people is that the traumatising nature of physical evidence productions within court may be lessened by that being able to be viewed digitally. Obviously, there's a huge benefit in terms of efficiency and all of that in terms of the digital evidence sharing capability in the system, but it is our view that it has the potential to reduce traumatisation by not having the productions getting passed about in court, and especially with regard to sexual offences. So we see it as positive.
And I think more broadly, one of the things that I think came from your submission was choice and the importance of choice being available to victims, where some of the provisions that are proposed may be relevant down the line in the event that the bill is passed. So how important is that with regard to the services that you provide?
Yeah, really important, and I suppose it ties into Adam's point he was making earlier on. There will be, I've spoken to this committee before around the kind of the emergency provisions in terms of the COVID bill, and remote evidence given in particular. There will be some people for whom, and we know this from our experience, for whom not having to physically go to court, so not, at the moment you've got CCTV rooms in court, so sometimes when people are given their evidence remotely, it still means they have to travel to a court and still be in the court building. That is hugely traumatising for a lot of people, a lot of concern around bumping into the accused or their family, and the way that courts are organised, that often does happen. So a huge amount of anxiety. Then there's the issues, as we've discussed a lot of time before in this committee, about adjournments, delays, deferments, and all of that building up your anxiety. You're holding on to remembering in detail what happened to you, because that is what you're going to get asked about. So you want to give your best evidence, you keep it at the forefront of your mind. And then, you've got all of this other anxiety that gets layered upon you about the actual, the physical court structure. So we are very much in favour of being victims and complainers being given choice about how they give their evidence. There will be some people who will choose to go to court and who will want to do that, so they should still be given the choice about that. But certainly in our experience, giving evidence remotely takes a huge amount of the anxiety out of it, and we also do think it will mean that more people are likely to turn up to give their evidence. It will reduce attrition in the system, we think, as well. And that's got to be beneficial in terms of, the delays that we're seeing, the adjournments, and all the rest of it. But I think, as I say, choice is absolutely crucial. And also in reference to Adam's point, the other thing to say in here is, as you know, I've said it before, vulnerable witnesses at the moment can give their evidence remotely. There's legislation already in place to do with that. And you do get supported to do that. It's not that you're being asked to provide that on your own without any support. So, that that I think is all helpful, but being able to, as much choice as we can give, as much range of locations, places, you know, to do that. And as you know, we've been developing our own to be able to enhance the choices that are available to victims. And if we're serious about reducing the re-traumatisation that happens just by taking part in the criminal justice process, then I think we have to be, you know, serious about offering remote evidence provision as a choice. Yeah. You know, what we worry about, as you know, is that re-traumatisation of the system itself puts people off from reporting in the first place. That is a big concern. And yeah, so we think it's helpful.
Okay, thank you very much. I think Rona Mackay, you want a supplementary, and then I'll bring in
a brief sup. And you've kind of answered what I was going to ask, and it relates to linking the issues that Adam talked about with older people maybe having access now but still not confident and maybe not that great. So you talked about support for people that maybe wanted to use it, but is there support there for older people who don't have the confidence?
So vulnerable witnesses, and that does include an older age group automatically, so they can, as you know, there's special measures that are available that the Crown can apply for. One of those is a supporter, and the other is providing evidence remotely too. So there, and those can be a combination of both, if you see what I mean. So if you're providing evidence remotely, you can have a supporter. Right. That is one of the things that victim support, for example, you know, a big part of our organisation is about providing support to vulnerable witnesses, either in court or in a remote setting, or a pre-recorded setting. So that is what, and there's a referral mechanism from the Crown to Victim Support Scotland for vulnerable witnesses to be referred to us, and an older age group would be included in that. Yeah,
that's really reassuring. Thank you.
Okay, thank you. Fulton McGregor.
Thanks, Convener, and good morning to both of you. My question is very much actually on where Audrey and Rona have been, so you've already started to answer it, Kate, and it does. But there's a couple of provisions I want to ask about, but in terms of the virtual attendance, I'm assuming from what you've said then that you are supportive of the measures in the bill, and you do feel that these temporary provisions should be made permanent.
Yes, yeah. I mean, I think it's. I've kind of talked to this committee, but it's been quite a while ago now, about the importance of something in legislation, because what I think we're needing is a cultural shift. We're not seeing it being used as much as we should, I think, especially given the amount of support that can be put in place for people. So I think it is really important that it's in the bill, and I think it's because that will help, I think, to cement the cultural shift that's required. There is, and it will help with a consistency across Scotland too, that I think we really need. So, yeah.
And before I come to Adam to let him speak a wee bit on this as well, do you support the development of fully virtual trial courts to deal with some type of cases? Cases that maybe people that have came to you would be involved in? So, sorry. No, so it's Kate, that was my fault. Kate,
sorry, I thought it was you.
Aye.
You're asking the question of me,
yeah.
Sorry.
Sorry, before I come to Adam.
So when you say fully virtual, do you mean absolutely every single part of the proceeding being virtual, or do you mean all the parties providing in the trial providing their evidence remotely?
Every part of the proceeding, yeah.
Every single part of the proceedings. Well, I mean, from a Victim Support Scotland point of view, we're most interested in the bits that victims and complainers are involved in having an option of being able to be virtual, having choice, as I say. I think and amongst that is really important, because there will be some people who will want to go to court. We're not, you know, there'll be others that are better placed, I think, to answer the question about different parts of the proceedings. For example, some of the evidence that was given earlier on around you know, custody hearings and all that kind of thing. But from a Victim Support Scotland point of view, we think it's really important that the option of giving your evidence remotely is given, and the choice is given to victims to enable them to participate without being re-traumatised by the system.
Thanks, Kate. And Adam, just on the same point with yourself, I take it you're supportive of these measures, and do you likewise believe that it should be made permanent as the legislation, as the bill proposes?
Yeah, of course. Thanks. Yes, I mean, broadly speaking, having that provision, and I think to Kate's point, the option available to people to use it is very, very important. And when it's required that it's be able to be supported en masse, I think what you will find in this, and actually thinking about, if we're going to look at victims of crime, but there'll also be people who are accused, their sense of feeling and attitudes towards that criminal justice system, have they been heard properly? Do they understand the process? And I think, look, we've all been on video calls at times and you're sort of beamed into something, then it ends and you're kind of, all right, was that it? You know, some people might want to make sure they've been part of more of this, that if they're seeking justice themselves, that video call just on its own might not be enough for them. But to what degree are they kind of communicated with, fully understand the process and supported to kind of give really good evidence to? But that, I think that provision of making sure that, look, in this circumstance, older people are able to and be supported to on a regular and consistent basis give virtual evidence is hugely important. But also I think it's important because, again, to Kate's point, we're doing sort of ping pong here and agreeing with each other, but for people that just that kind of travelling and the kind of trauma to some degree, but the challenges around that, and when cases aren't seen that day, that people are able to, they might change their mind next time I want to give virtual evidence, but how do I do that? And I think for a lot of these system changes that people need to be brought along with this as well, because as we've seen with, you know, we've gone through the mill on this, on the hate crime legislation, but looking at some people that are victim of hate crime, not feeling that they're really taken seriously, that they don't want to keep reporting things, they don't feel the system really works for them. So this is a great opportunity with this bill, not just on the actual provisions in it, but about how you're giving the public confidence in a system that also works for them and not just kind of the inner sanctum kind of processes too.
Yeah. Sorry, yeah.
Can I just come back in there, because I think as well it's a really important point that Adam's making, which and I think the thing we need to remember around this point around accessibility and inclusion is that we need to be honest that our court buildings, generally speaking, in Scotland are not that accessible, and it's not that physically going to court is a more accessible experience than online, because it's often not. The acoustics in courtrooms can be often very difficult, as we all know, really difficult to hear. You know, in terms of physical access, it often is not great either. So there's you know the traumatising impact layered over and above that. So yeah, it was just to add to that, just that point about being honest with ourselves about the accessibility of the current court estate, which is not, you know, there's definitely issues there.
Yeah, and I think what you're both saying is that it's important that people have got choice and informed choice about what options best for them. I've just got one further question, convener, if that's all right, and that's actually on the first area the bill proposes to move from a temporary provision to permanent, and that's the electronic signing and transmission of legal documents in criminal cases. Do you regard these provisions as helpful, or are there situations where, you know, it might be more helpful for the people that you work with to do it by old-fashioned paper? Adam?
I think it goes back to that point about choice and what people are able to do. Kate and I and colleagues were chatting earlier on about digital signatures and thinking, well, if I can sign a mortgage application digitally and that's got some legal grounding, then being able to do that in other circumstances as well would be good. Look, for politicians, you've probably all had to sign nomination papers at times for these wet signatures, but actually, what effect does that really have apart from knowing that you've actually undertaken it? I have signed this thing. I think it's definitely important that those who just aren't able to, don't feel comfortable in it, you know, might have medical conditions that sort of, depending on how it's signed, preclude them from doing so, are able to and be supported to quickly and effectively provide that wet signature, but that might be digitised later on by the service.
Okay. Kate, you want to add anything?
Yeah,
there?
I mean, we see the big benefit of this really in being in the kind of behind the scenes work that goes on with bundles of documents getting sent from, you know, from court to court, all that kind of thing, we see that as hugely beneficial in terms of taking out the inefficiency that there is around that at the moment. But yeah, totally agree with Adam's point that if there is an ability to make, you know, where there's a requirement for a complainant or a witness to sign documentation or whatever, that there is an option to be able to do that electronically for people who want to do that. But again, really important that there's as accessible a process when that has to be done and should be done in a, you know, paper documentation. So, for example, witness statements. You know, we've got a portal now, the Witness Gateway, that puts witness statements on an online portal that people can access. But it's really important that that's not the only way that you can access your witness statement, that if you want to be able to see and read the paper copy, that you're able to do that, and that process is there are no barriers to that process, and it's as easy as it possibly can be. So I would just use that as an example.
Okay, thank you. I'll bring in Ben McPherson for a follow-up question, then I'll bring in Pauline McNeill.
Thanks very much, Convener, and very empathetic to what's been said already this morning, and I think you make compelling points. I just wanted to go back on some of the points that were involved in the answers to my colleagues' questions, and what the previous panel spoke to us about in terms of practicalities. You know, do you have views on what facilities should be available for people to give evidence? Where that should be? Does there have to be agreement with local authorities? You know, you know, where obviously some people it will need to be facilitated by the Crown, but if you know, would you see people giving evidence from their home? I presume probably not, from what you've said so far. But you know, just I think it'd be good for us to hear about your thoughts on the practicalities, particularly given what we heard earlier this morning.
Yeah, so SCTS have got you know, they're expanding the amount of remote evidence suites that they're providing, and in Victim Support Scotland we have been running a programme alongside in anticipation really of this. So we have a facility in Glasgow, we'll soon have a facility in Edinburgh, Aberdeen and Inverness, and that will be, you know, in secure internet, highly soundproofed rooms, so that you can't hear outside, because that's really important as well, to keep you know, to keep that element of confidentiality. So we've got really quite highly spec'd out, and our view is that we run in parallel with SCTS and be as you know, as supportive as we possibly can be in terms of providing facilities and the resources potentially to help make this happen. I think some of the challenges come around where you're running that in parallel and at the same time as court proceedings that are running in court. So there's no doubt that for some organisations it does add into the amount of resource. So, for example, in Victim Support Scotland, it will give us a bit of a logistical challenge that we'll need to overcome, which is, you know, there will be still probably witnesses giving evidence in court, and we'll be then court supporter for them. So we'll need people in court at the same time as needing to have people within either our offices or the SCTS remote evidence suites, so that they you know, you're adding to the volume. The trade-off, I think, for us is when you're running it alongside what we're seeing as the summary case management approach that's going on within sheriff courts, where you're reducing the number of trials that are being scheduled that don't go ahead. There's a trade-off there, because at the moment we're putting a huge amount of resources, you've heard me speak about before, into court to support witnesses, vulnerable witnesses who's then are not called to give evidence. So that's a hugely, it's inefficient just now. But our view is that it's because of the benefits there'll be in terms of reducing trauma. We'll work through those challenges in terms of capacity.
How much time do you need to work through it? How much time do you
Well,
think?
we are supporting it just now. It's in the protocol. We're ready. We're available. We're working alongside SCTS and COPFS. So it's not that we're not. You know, this is an ongoing dynamic, I guess, planning situation. We're hoping that a lot more of this will be done, basically, than is at the moment. But what I'm saying is, I do appreciate the challenge that some others have got. We see it as a positive and a benefit, and that's what we're working on. And also because the summary case management is reducing the number of, that's reducing the amount of people that we're needing to put in court, so we're moving them to other places. Do you see what I mean?
Yeah, absolutely. Don't doubt that it can be done. I guess I'm just trying to get a sense of, if we were to pass this bill as a parliament, what's the time frame realistically to enable the practical delivery of something that would, you know, from everything you've said before, I'm compelled that it would make a difference.
So in terms of the evidence, the remote evidence given suites, we are working on the basis of, we've got Glasgow just now, we're working on the basis of Edinburgh, Inverness and Aberdeen being ready in this calendar year. So we're well on the way with that, and then we'll take a view and work with SCTS about plans after that. Resources, if we're needed, we need to do it just now. So vulnerable witnesses can already give evidence, remember, remotely. Yeah. So that's the situation that we're in at the moment.
Yeah, no, I appreciate that. It's just that was really helpful, particularly in regard to the discussion we had this morning. So thanks for providing a bit more on that. Thank you, Camille.
Okay. Pauline McNeill.
Good morning. Still is the morning. It was just a follow-on from Ben McPherson's questions about virtual attendance, and I've had the opportunity to visit your offices, Kate, and see the facilities for giving remote evidence, and very, very impressive. The bill says that so it allows virtual attendance for we're talking about non-vulnerable witnesses, as you said, where it's in the interest of justice to do so, so it's not an automatic right or anything like that. I wondered if you thought, given your answer to Ben, and I know the facility is really top quality, that it's quite important to develop these facilities, because I imagine that's the sort of thing the court will be interested in. It has to balance the decision for witnesses, in particular, to give evidence virtually, that those facilities that you have and are developing is maybe quite important for that test.
Yeah, I mean, it's interesting because ultimately we would prefer that the decision and the choice is with victims, and this is a discussion that we'll have, I think, in the Victims Bill, and some amendments potentially around that. Because you know, our view and our experience is that it could be, it's not used enough, and it could be used a lot more, even with vulnerable witnesses. And one of the, you know, and I understand the pressure, particularly around police officers' time, and for police officers to be able to give evidence remotely. And I totally understand that, but I don't want us to lose sight of the fact that vulnerable witnesses already have that ability, and as I say, we should be using it a lot more in that context, and actually given choice. It's back to what I said earlier on about that cultural shift. And yeah, you're right, some reassurance around the type of facility, you know, there is a bit about, I think, just demonstrating that it actually works. Our facility's been signed off by the judiciary and SCTS and COPFS, but there are still a number of barriers, I think, that need to have been worked through for this to become much more of the norm.
Yeah, take your point, but just the bill itself, there's still a test that has to, how they apply that test, it's not automatic. So therefore, that's my question. I think we've answered that. Well, I know your position in relation to choice, but the bill is not giving that choice, it's saying it's in the interest of justice to do so. And with your answering, I think, yes, to my question, which is these facilities that you're developing will give reassurances to the court system, if you like, that the way in which, because witnesses obviously still very important that they give evidence in certain conditions, but that would perhaps meet the test that the court will have to apply if the bill is passed without amendment, if it's in the interest of justice to do so. Yeah. I just wanted to... Did you want to answer that, Adam?
Just to your point, and actually to Mr McPherson's point as well, I was going to sort of slightly jump in on the kind of where and what as well, but your point about the language in the bill, that gives quite a lot of wriggle room not to do something, which could add tremendous value. So I think that's something which needs consideration. So when we're talking about this and the inconsistencies and how the measures that are already in place are applied because of, you know, judge or sheriff or whoever feels that they what they want to get is important, but actually how do you get the best quality evidence from witnesses too? But sort of slightly going back to Mr McPherson's point, and I think fits to yours, is like actually, look, if we're looking at in this bill to modernise and digitise the kind of administration of the whole system, does that free up kind of people time, right? And actually looking at where resources go to support witnesses, you know, I'm thinking there's an element, actually, I think there will be people who probably could and should give evidence from their own home, but not necessarily, let's say, they get a joining link and sort yourself out, because actually, is there someone like a liaison officer can go there with the right kind of technology? It's very simple stuff to make sure that they are, it's the right kind of evidence, because in the courtroom, presumably, like, you want to have high quality kind of communication of that. So if a judge or a sheriff doesn't think it was very good quality, they won't be minded in the future to use that again. If someone's joining by a device that's not really working, or the sound's not working properly, the microphone. So is there kind of like some kind of standard kit that could be used in those circumstances? And there, of course, there are facilities around the country being set up which are to support that. Could these things also be set up as standard if they're not already in current courts? So that actual public building, you could go to another city or town, in a sense, virtually, too. But I think the language was Neil on the kind of that wriggle room, I think, is important, so it doesn't, if the aspirations for high quality evidence that people feel supported, they've got good access to justice and felt the system worked for them, but they actually can't access it at all because somebody has said no, then it's sort of a missed opportunity to standardise people's experiences wherever they are in the country.
Yeah, well, we can only guess what is meant by in the interest of justice to do so. But I think what you say, if what you're saying is, well, whether it means someone can give evidence in their own home, we don't know that. But supposing would allow for that, then I would have thought, then, if what you're saying is there's an imperative then to develop systems, notwithstanding the point you make in your submission, which is for the person who's really maybe struggling with technology, but in order to also make sure that would you accept it's not just a question of that, the quality of that evidence as well? So I suppose the two marry up together, don't they? Yeah.
They do, definitely.
I mean, I found your submission really helpful because I think it's a bugbear of a lot of politicians, although that we like to see modernisation and change for the better, and digital platforms give that, but you don't want to throw away the opportunities to people to do it the way that they prefer to do it, have been able to phone rather than email, been able to see the hard copy rather than the... Because some people will have... That's what I think, to me, that's what your submission really speaks to, and I found it really helpful.
That's helpful. I just think on some of this, I'll stop in a second if you don't mind, Convener, but on the how people are interacting with these services is hugely important. I've said that earlier on, but we're also looking about how, you know, a system can kind of just assume that people can do something digitally, or in a sort of a throwaway comment, can you get someone else to kind of help you do that? You know, we've seen this in other public services. Well, we'll email a family member this document, but actually you might not want them to see that. You might be, particularly in kind of court cases, you might how you access that private information is really important, and not giving away and giving up some of your own independence. And we also see this with regard to issues of elder abuse and other places around that where there are relationships which are challenging. The system, the state, however, could just almost accidentally support someone losing their independence and say, well, someone else can do it for you. So it's possible to access it, but actually that human being is just being kind of cast aside, and I think that's really important to avoid. So let's digitise a system in terms of process and admin, but interaction points have got to be quality.
Yeah, thank you. to be fair, you'll see that we're all still using paper here. There's a certain insurance policy, I think, for us to have paper in front of us. No further questions. Thank you.
Okay, thank you. I wonder if I can just come in with a question, and it's probably one for Kate. Quite a significant part of your submission details your views around broadening the scope of the bill, in particular Part 2, and including child homicides or suicides. So I'm just interested in, interested in a little bit more about, to hear a bit more about the thinking behind that and why you feel that that would be important to include.
Well, first of all, what we should say about Part 2 is that we're really, as I say, really happy to see a statutory review process of homicide and suicide in the context of domestic abuse being set up in Scotland, and the collaborative approach that's been taken to developing that has been really, really helpful, and learning from other countries who've had similar provision. And I think it's because of that. I totally understand the rationale between having a tight scope to start off with, and then potentially being able to expand that later on to, for example, include honour killings and that type of thing. So yeah, we would see that as beneficial. One of the things that we are really pleased about is the inclusion of in terms of connected deaths, that for example around children. We think it's, all of this is really important from a perspective of learning and understanding the full impact of domestic abuse, and being able to learn from that, and potentially make some changes that could prevent potentially some horrendous and tragic situations happening in the future. So the ability to have a conversation, for example, around with child protection, around the types of reviews that they might do, make a decision about which one potentially should go. Is it needed? Do you need to take the connected deaths forward as part of this review, or will that be picked up elsewhere? Just to, from my perspective, is to make sure that there's nobody falling through any of the gaps. So, for example, a child who is on a sleepover at a house, there's and where there's domestic abuse situation occurs, and that child is killed as in the context of domestic abuse. There may not have been child protection proceedings going on around that child. That the child has just got caught up in that situation. So for that, I think it's really important that children killed within the context of domestic abuse are included within the scope, and that it's really important that connected deaths are looked at, because that's one of the areas where there could potentially have be a gap, and you're missing an impact of domestic abuse then if you're not including that within the scope. But I do think that it's struck the right balance around, linking in with other types of review processes to see which is going to be the best option going forward, and expecting that joint conversation to take place. So does that answer your question?
It does, yes, it does. I will be honest, I was just slightly unclear what you were looking at within, or what you'd set out within your submission. So that's been helpful in clarifying what you understand by and what you mean by connected death. Just on the review process, I suppose one of the other things that picked up from your submission, or a couple of things, was around membership of the Review Oversight Committee, and also you set out some thoughts around access to a report that is produced by the committee, and specifically you feel, or you believe, that it's pertinent to allow families to access a full copy of a report if they wish. So I'm just interested in any more detail that you would care to share on those 2 points.
So if I'll take the membership of the Oversight Committee first. I mean, I'm assuming it's to do with trying to avoid conflict of interest, that there's provision in the bill to exclude people who've either supported or or been involved in an organisation that supported victims of domestic abuse and victims. What was interesting to me about that is if it's about a conflict of interest, then it seems to me there's a bit missing there, which is about a similar provision for organisations that work with perpetrators or perpetrators of domestic abuse programmes. And why, if it's about conflict of interest, my question was, why wouldn't those groups of people be excluded from the Oversight Committee too? Because surely, in terms of thinking about conflict of interest, there's a potential there too.
Okay.
So that was something that I thought potentially I wanted to explore, because I do think it feels very uneven and unbalanced at the moment, the way it's written in the bill. The second thing that you were asking about, sorry, remind me.
It's just about the report.
The families,
yeah.
So there's I think some more work to be explored around the involvement of families, because I think sometimes in these reviews families will be a really rich source of information as well to inform the review, particularly in situations where other agencies have maybe not been involved. So there's, and if you're looking for learning really about potentially opportunities that have been missed or things like that, I think families will have a really important role to play in that review process, potentially. We totally understand the rationale between this point about anonymised reports, and my understanding is that the approach that's been looked at is to have a summary report that's quite high level, that it's anonymised, and that will be in the public domain, but have a much more detailed report that goes to all the organisations involved. And from our perspective, there's a few things, because obviously we are fairly unique in that we've got a service in our organisation that supports families bereaved by murder and culpable homicide, as you know. So making sure that it's absolutely clear to families about when reports are going to be released, that they do also get copies of the full report shared with them. The organisations that are potentially supporting those people, so for example us, that we get a copy of that full report too. It'll be really important for us in terms of being able to support somebody and understanding, families will be really interested in understanding what the learning points are and what's going to be taken forward as a result. Because as you know, and I've said before, most people, what they want is to make sure that nobody experiences what they've experienced. So that will be really important, and we'll only be able to do that if the full copy of the report is shared with us too. And I've shared with the task force group, my views about being careful about time and having conversations with families around that, being really clear about what types of information is going to be in the public domain, and there is also the point that we're picking up elsewhere too around the impact of potentially being able to identify surviving children, for example, and the potential that might trigger around media attention and all the rest of it. Really important, you've heard me say this before, but any official documentation that goes out into the public domain tends to trigger media and social media responses, true crime bloggers, vloggers, all of that kind of thing. So really making sure that there's, and we're not that big a country either, so making sure that there's support for people as well, and that we try and avoid the intrusion into people's lives as much as we can from that aspect too, and be mindful of it.
Okay, thank you for that. Just before any other members want to come back in, you mentioned a while ago forced marriage and honour killings, or one of the two, I can't remember what you referenced. I have to say, I'm surprised that's not included in the provisions of the bill, and I was just interested in what, if any, comment you would have on that.
Well,
that type of violence, if you like,
Yeah.
potentially not being included in the review process.
So I think the intention, my understanding, so it was honour killings that I mentioned, and my understanding, but obviously there'll be others that are coming to talk to you about this in later sessions, is that there is a desire to include honour killings, for example, but they're super aware that this is a new process, and really want to make sure that it's set up and it's because the scope, particularly including suicide within the context of domestic abuse, becomes quite large. So I think the explanation that's been given to me is there's a desire to make sure that we try not to run before we can walk, to give it the best example, and get get the review process up and running, and then there is provision in the bill that allows the scope to be expanded further, and the expectation is that that will be done, and will include, for example, honour killings.
Okay, thank you. Any other members want to come in before I... No, I've got a couple of other questions, so just again for Kate Wallace. One of the proposals in the bill, again with regard to Part 2, is that reviews could potentially be carried out in parallel with other proceedings. So, obviously, for example, criminal proceedings. However, the Lord Advocate would have sort of discretion to pause a review or end a review, obviously in the spirit of preventing sort of prejudice to other proceedings. I'm just wondering, I'm just interested in your views on that provision, if you think that that's an appropriate arrangement.
Yeah, I mean, I suppose we can completely see the rationale of trying to capture information and experiences early while it's fresh in people's minds. So we can completely see that, especially when you think about the length of time for solemn cases in particular, in terms of how long they're taking at the moment. So we can see the rationale for that, but we do want to explore that in more detail around, because we do want, obviously, some assurances to make sure that it's not going to prejudice criminal proceedings too. And there's a bit, I think, to be worked out as well about just we want to find out a wee bit more about what the approach will be in terms of involving families and how formal will that mechanism be, and how will people be supported to take part in the review process too. So we've got some kind of questions around all of that aspect of it that we'll pick up with the team.
Yeah, okay. Rona Mackay, do you want to come in?
Thanks, Kavina. No, it's just, I think I know the answer to this, but I'll ask it anyway. So it's just about how important is it for a review to be established quickly in terms of the family's perspective? Your views on that. I think I know the answer to it.
Yeah, mostly it's and again there potentially will be some exceptions to this, but for the most part, yes. And for the most part, people understand that capturing information at a really early stage is really crucial. And while it's fresh in people's minds, so I think there's a lot of support for that, but understandably some questions about what that means in terms of criminal proceedings and just making sure that that's managed properly, I suppose.
Yeah, thank you. Thanks.
Thank you. If members don't have any more questions, one final one that I think probably is for Adam, and it's just something that sort of came into my mind just now, and that's with regard to Part 1 and the provisions within the first part of the bill and capacity. So, we've spoken and we've heard you obviously outline some of your views with regard to choice for older people in particular. I'm just wondering where perhaps we have an adult who finds themselves, an older person, finds themselves in the criminal justice system, or even the civil justice system, I suppose, for that matter, where there may be issues around capacity and what maybe needs to be considered so that the provisions within the bill, as they stand in Part 1, still remain relevant and accessible for somebody where there may be questions around capacity. And I'm thinking maybe where you might have POA or guardianship, just for example.
I think it's a really good question. I'm glad you asked. I think one of the things we need to really mention about capacity is that there's a perception about people's capacity as well, sometimes built into the system. People might have a dementia diagnosis, for instance, but doesn't mean they're not fully independent and they have their own capacity. We often see this even with the POA system, and that some solicitors don't want to get involved in dealing with POA for people who might have a dementia diagnosis, because it is not a fixed capacity, and one day will be different, throughout a day will be different as well. But you're right, in terms of that, I don't have really much to say about how you would do it really well if you've got a power of attorney in place, because there's obviously a lot of legal kind of responsibilities around that. I think for probably real experts in this, but I think where there is perception of capacity, or for instance somebody does have a dementia diagnosis and it's maybe at an early stage, that how the system or how the state kind of treats or interacts with them is really important. They shouldn't be dismissed at all. They shouldn't be like speaking to somebody, not to them, about their circumstances. Incredibly important. I don't think there's anywhere near enough training and awareness in the public sector and service about how to properly interact with people, let's say with dementia. I'll use this as one example. I think it'd be really important to capture evidence well early, at a time that suits them, and some of this evidence might be recorded as well to make sure that it's as fresh, because it won't change, just how the person articulates at another stage or another place or an environment which is not too comfortable to them or is unusual might really affect what they say. But there's definitely a lot about perception on somebody if they're older, and as we know at Age Scotland from years of kind of discussions around access to criminal justice, that where sometimes people are not taken seriously, so not seen as a reliable witness because they might just not be able to articulate something. It might not be about capacity really, but where police officers, for instance, don't really feel what they're getting is what they need, and therefore things won't proceed. And I've had really good conversations with deputy fiscals about this over the years. So sorry to ramble on a little bit, but I think there's definitely a lot about awareness of how people with perception of capacity issues are treated, but definitely getting in early at the right time, and people are supported to give good evidence, and that should be treated as valuable as when it was taken as it might be in a live kind of court setting, so that cases don't fall or fail because that person isn't able to articulate that thing properly on the day.
Okay, thank you. Thanks for that. It's very helpful. Kate, do you want to add anything to that?
I wanted to, if I could, just because I'm aware we'll be finishing up, something that I meant to say just when you were talking about the involvement of families within in part 2 in terms of the review process. One thing that we picked up was that there's currently no provision within the bill to ensure that the family are notified that a review has been taken, that a review will take place. So we do have a bit of a concern about that, given the feedback that we get from families about lack of information and how that can re-traumatise them. So I think that's something that should be addressed in terms of notification. So that was what I wanted to say about part 2. Just before we finished, I wanted, because one of the questions that I thought I might get asked, but I've not been asked yet about part 1, is there anything missing? From part 1, in terms of some of the temporary COVID measures that were in place that are not within this bill, that we've got a concern about, and that I know there's views about it, time bars. I am concerned really that we've got, as this committee has heard before, 2,000 solemn cases waiting in the High Court that will hit a time bar in November 2025, so November of this year. So I want to take the opportunity to say that I've got real concerns about that, in terms of if we don't do something about that cohort, that very specific cohort that's been, had a very different journey through the criminal justice system because of COVID, that I've got concerns about the impact of the amount of administration if every single individual case an extension has to be applied for. and the amount of administration and resource and capacity that will take up in the system. And I'm also concerned, as I've said to this committee before, about the potential risk of cases timing out and victims not getting justice. So I'm disappointed that there isn't anything in the bill about that, because I do think it's a big problem, and I know the committee have had conversations and there's different views about that. But I wanted to put on the record my concerns.
No, that's helpful, and I was actually going to finish up just with a question, if panel members had anything else that they specifically wanted to comment on that we hadn't perhaps picked up in our questions. So that's very helpful. And so I don't know if you maybe heard the evidence of the previous panel with regard to time limits. So that's obviously an issue that organisations and stakeholders are well cited on. So I appreciate your comments. So on that, Adam, is there anything else that we've perhaps not covered that you'd like to just bring up? No. Kate?
That, while you're asking that question, which is to do with, because we haven't talked about the provision within Part 1 for cases being heard, the location basically of courts, and where the cases are going to be heard. So the national jurisdiction for Collins from custody, for example. One just point that we would want to make about that is just being really careful that that does not result in victims having to travel big distances to go to court if it becomes about you know, where the accused is being held. So that's our concern. So we think that, you know, sheriffs and judges should be taken into consideration where victims and witnesses actually live before the decision's been made about the court that will be used.
Okay, thank you. And again, that came up in our first panel. So we will have Crown Office and courts, Scottish courts in next week. So there'll be plenty for us to ask in and around the sort of logistics, if you like, of court processes. So, okay, thank you very much indeed. That's been really helpful. And with that, we'll now move into private session. Thank you.